these customers whole, or as whole as they can be under the circumstances. I think the evidence will show that there was confusion as to when SIC would terminate its service. I also think that the evidence will show that there were customers without service for months who kept paying their bills out of fear that their bill would ultimately go to collections and impact their credit report. While sanctions are clearly warranted under SIC's violation of the notice requirements under HAR 680-123, these notice requirements are just the first prong of that rule. As the Commission is aware, and as it referenced in its order to show cause, HAR 6-80-123B gives the Commission power to set reasonable terms and conditions of discontinuance and to even deny the discontinuance unless the carrier demonstrates that a reliable, competitive alternative exists at reasonable rates. So based off of that, our office is advocating for the Commission not issuing an order allowing SIC to abandon or discontinue its service until it is shown that several things are satisfied. First, SIC should show that it has waived and reimbursed any customer termination fees in the last 3 months. SIC should be required to show that it has fully reimbursed customers who request to terminate service, or excuse me, who had requested to terminate service or remove auto bill pay features, but was that request was unduly delayed in the prior 3 months. And we also believe that SIC must show that a reliable, competitive alternative exists at reasonable rates for all customers who were on SIC's books as of June 9th, 2024, the day before SIC unilaterally decided to terminate service. In addition to the above requirements that the Commission can impose at the state level, as noted in the document production from the Department of Hawaiian Homelands, in the June 6, 2024 cease and desist letter from the Wireline Competition Bureau of the Federal Communications Commission, SIC is also required to comply with certain provisions of the Communications Act of 1934. For the record, this letter starts at bait stamp number PUC DHHL 6 000005. So therefore, the Commission's order should also clarify that SIC may not be allowed to terminate service unless or until it attains a certificate from the FCC as is outlined in that June 6, 2024 letter. Additionally, SIC should be ordered to come into compliance with all regulations, both federal and state, relating to number porting, as well as all regulations and contracts related to conduit occupancy, which would include requests to furnish make-ready work. The consumer advocate also believes that for every instance where SIC has wrongly refused to port a customer's number, the Commission should direct SIC to refund that customer the difference between what it has paid to SIC since initiating the porting request, if any. Finally, 2 more requirements that the consumer advocate offers. The Commission should direct SIC to timely respond to, fairly consider, and approve all future bona fide conduit occupancy requests within 24 hours, or per any contractual obligations, whichever is sooner. And finally, the Commission should consider issuing appropriate penalties to SIC, including fines not to exceed $25,000 per day for each violation of any of the above directives pursuant to HRS 269-28. Frankly, based on past history, even if the Commission issues an order with the above requirements, I'm not sure if SIC will comply. I'm not sure if SIC will restore service to customers who want it, but that doesn't mean that this Commission should absolve SIC or any other related company whose corporate veil is pierced of any future liability, both civil and criminal. And again, when I talk about civil and criminal liability, the thing that sticks out in my mind is that customer, that very real possibility that someone tries to pick up the phone and call 911 and they can't do it. That said, I know that there are Herculean efforts being made by the Department of Hawaiian Homelands and its staff to make sure that that nightmare scenario doesn't happen, at least on a temporary basis. But if something should slip through the cracks, that should fall on SIC's shoulders until SIC's customers are, again, made whole, and, again, reliable alternatives exist for those customers. Thank you.
Thank you, Mr. Boone. We will now proceed to the examination portion of this hearing. We're just going to do a quick check with our court reporter. We're okay there?
Yes, I would prefer that Mr. He
Okay.
testify sitting in his chair rather than
Mr. He, if you would, if
I gotta take all this with me.
can we accommodate that?
Can
staff?
I roll the desk?
Like a desk, another desk to be moved out here? Yeah, why don't we take our brief recess, 5 minutes, we'll set everything back up.
Sorry, you're all the way over there. I know he's not further away from him.
back from recess. We'll begin now with the examination of Sandwich House Communications. Mr. Hia, remind you that you are still under oath. So we will proceed with your direct examination.
Thank you, Mr. Chairman. For convenience sake, or I would just as soon not question myself, but if for clarity's sake, you would like me to ask a question and then answer it, I will do it that way. So you know what my point is, I'll leave it to you. Or why don't I, if it's all right with you, I'll do a combination of both. And if you don't understand why I'm saying something, stop me and say, can you ask a question? And I'll ask a question, and so you can,
Yeah. Mr. He, why don't we just do testimony, right?
Okay.
Just go through your testimony, and then if there are questions thereafter, we'll ask them of you.
that's fine, Mr. Chair. The reason that you need to go back 30 years ago, that you cannot go back 30 days ago, comes down to how Sandwich Isles was formed and what the authority of this PUC is. So unless you go back 30 years ago, you cannot come to an informative decision about what this PUC's authority is. So 30 years ago, Hawaiian Tel would not provide service to all areas of Hawaiian homelands. Hawaiian Tel had a CPCN from the PUC, which required it to provide carrier of last resort service throughout Hawaii. At that time, the PUC had a two-tier level of service, whereby urban Honolulu had one level and the rest of the state had another level. However, the carrier of last resort obligation transcended those two levels. The PUC at that time refused to require Hawaiian Tel to provide service that it is now requiring SIC to do. SIC doesn't have a CPCN. At that time, Hawaiian Tel had a CPCN. The PUC did not require Hawaiian Tel to provide carrier of last resort obligation. But you're trying to require me to do it under a certificate of authority. Recently, the PUC approved Hawaiian Tel giving up its CPCN and issued them a certificate of authority. So now you end up with no one having carrier of last resort obligations. The carrier of last resort obligation that SIC operates under is contractual with the DHHL, with the Department of Hawaiian Homelands. It is integrated into the easements upon which SIC built the infrastructure. Okay. The way we got to that is 30 years ago, DHHL, when they had no other choice, they could not get any relief from Hawaiian Tel and they could not get any relief from the PUC. They approached me to see if I could solve this problem. It was a safety issue, but it was a safety issue beyond just individual safety. It was a safety issue from the standpoint of DHHL could not fulfill the obligations under the Hawaiian Homes Commission Act because most of its land is unserved. And so they couldn't give out land to Hawaiians because it was unserved and it would create more safety issues. Okay. Instead of requiring Hawaiian Tel to provide service, the PUC at that time decided, well, you know what, we actually have very limited authority over Hawaiian homelands. And so it basically abandoned Hawaiian homelands. Okay. And there is a record of the correspondence between the PUC and Hawaiian homelands. How many copies do I give? They have it. Yeah. Do I give it to the commission? Do you? Is that enough? Does council need it? Need some more? Yeah. Yep. You good? You need one? Okay. So in this packet that you received, that you just got, okay, the question is asked by, we were applying for loans, and so from RUS. And so the question was asked by the director, Ken Chandler, at RUS, to the PUC, what is your authority? Because there was confusion about what the authority was. Okay, and I highlighted the questions, et cetera, et cetera. And the PUC came back, with a response from Clay Nagao, who was chief counsel at the time. And unfortunately, that response created more confusion, because in here it says on paragraph 2, if the FCC has regulatory authority in these areas, the question was, if the PUC has regulatory authority in these areas, will it exercise such authority? And the answer was, whether the PUC will exercise its authority over Sandwich Isles Communications is a decision that the PUC will make in the context of a formal PUC proceeding pursuant to HRS 269-7.5. Okay. So the difficulty was with RUS was they needed to understand the regulatory authorities that lay in regards to Sandwich Isles, because we were borrowing funds to build out infrastructure, and under their regulations, under the Department of Ag regulations, they could not lend us funds if we were going to build or overbuild areas where there was already a telecommunications carrier. So they needed to understand who had authority here. Okay. As a result of this response that Mr. Nagao sent to Mr. Chandler, I wrote to Mr. Naito, Chairman Naito, and I asked him 2 questions, and that's in that September 1st, 1995 letter that you have. Would the PUC agree that the Hawaiian Homes Commission has the power to authorize a public utility to provide service on its lands? And 2, would the PUC agree that the public utilities do not have the ability to use their power of eminent domain to acquire easements for utility services on Hawaiian homelands? These 2 questions were asked because those are 2 of the essence of regulatory power on public utilities. Okay, there's others which I'll come to shortly.
Mr. He,
Yes.
I'm sorry. Just we have to kind of gain a little more control over just the procedural process,
Sure.
making sure we're taking in your evidence properly into the record. So we should have done this earlier, so our apologies, but we'll do this for every additional exhibit that you offer. For this one, you've given a copy of it to our clerk, and what we'd like you to do going forward is simply to identify what it is that you're offering to the commission. Just tell us, what is the document very briefly. So here we have a letter dated July 18th, 1995. It looks like it's from the PUC to Ken Chandler as director of USDA. That's just some kind of basic information.
I
And then you
understand.
would say, we're offering this into evidence. Christian then will tell then all of us what the marking is for this exhibit. And this is SIC number 1. Is that how you've marked it, or exhibit 1? Okay, so this is SIC exhibit 1. Then we will ask the consumer advocate whether you have any objection to this document, SIC exhibit 1, being offered as evidence in this proceeding. It appears to be an official government communication. So just to go backwards a little bit, do you have any objection to this being offered into evidence?
No objection to the letter dated July 18th, 1995.
That's been marked as SIC exhibit 1? Okay.
Thank you.
Yeah, let me just clarify. So, right now, SIC Exhibit 1 marked is entire packet, which includes also correspondence between Sandwich Isles Communications dated September 1st, 1995 to the PUC, a response letter from the PUC back dated September 20th, and then also what appears to be a USDA letter to then and current Chairman Kali Watson of the Hawaiian Homes Commission dated October 20th, 1995, and then the last item in this packet is a letter dated October 30th, 1995 from Mr. Watson, from DHHL to Chairman Naito of the Hawaii Public Utilities Commission. So that's the entire packet. So,
No objection to the entire packet being admitted and identified as SIC Exhibit 1.
okay. So we will we'll admit this as evidence, SIC Exhibit 1. Mr. He, if you kind, I think for the court reporter's sake, this is what we've been talking about and what you have been reading from. But if you want to refer to it as,
Okay.
such and such item in SIC Exhibit 1, that would be helpful.
I will try to do that,
Yeah,
but
thanks.
if it's confusing, please stop me.
Yeah.
And I'll
Thanks.
clarify it. Okay. So the let's see. In SIC Exhibit 1, it contains a September 1st, 1995 letter to Chairman Naito from of the PUC from me, asking 2 questions. Would the PUC agree the Hawaiian Homes Commission has the power to authorize a public utility to provide service on its lands? And would the PUC, and 2, would the PUC agree that public utilities in general do not have the ability to use the power of eminent domain to acquire easements for utility services on Hawaiian homelands? SIC Exhibit 1, letter dated September 20th, 1995, from Chairman Naito of the PUC to myself at Sandwich Isles. Answered those 2 questions. Pursuant to Section 207C1 of the Hawaiian Homes Commission Act, it appears that the Hawaiian Homes Commission has the power to grant licenses as easements for telephone lines and other utility services. Second question regarding eminent domain, pursuant to the State of Hawaii Attorney General Opinion 60-77, it appears that a public utility may not acquire any Hawaiian homelands through eminent domain proceedings, in spite of the right of eminent domain granted to public utilities by Hawaii Revised Statutes, Section 101-4. So what we're trying to do was narrow down so that we could qualify for loans. We're trying to meet the requirements that USDA had before it could issue a loan to build the infrastructure. Exhibit 1 has a letter dated October 20th, 1995 from USDA, from Mr. Bob Peters, the Assistant Administrator of Telephone Program, to Mr. Cully Watson, the Chairman of the Hawaiian Homes Commission. And he stated very clearly in the first paragraph, our regulations require clarification of jurisdiction role the Hawaii Public Utilities Commission will have over Hawaiian homelands. Once this issue is resolved, we will be able to grant interim approval to Sandwich Isles to proceed with some of the construction in its loan application. On the second page, and these are highlighted, it says the PUC has generally recognized the Hawaiian Homelands Commission has authority to determine which company can provide telecommunications service on Hawaiian homelands. If this is accurate, they'd appreciate a letter. It is, and then he goes on to say it's imperative that those questions be answered before they could issue the loan. Then the last letter in the Exhibit 1, SIC Exhibit 1, is October 30th, 1995, from Chairman Cully Watson of the Hawaiian Homes Commission to Chairman Naito of the Public Utilities Commission. Highlighted portions: the majority of our lands are located in rural areas which are therefore subject to high costs of installing service. Furthermore, some of our beneficiaries are currently being provided party line service. We understand that the Public Utilities Commission recognized the Hawaiian Homes Commission's authority to grant licenses and easements for the provision of telecommunications service, and that DHHL is not subject to eminent domain proceedings. We are concerned that there is a continuity of service while this transition is made from GTE Hawaiian Tel to Sandwich Isles. At that time in 1995, it was the Hawaiian Homes Commission's decision that Sandwich Isles would be the only provider of telecommunications on Hawaiian homelands. It would occur over many, many years, probably 50 years, but it would occur. That was where the Hawaiian Homes Commission was headed. Mr. Chairman Watson signed the license, but this initiative was made under Chairperson Holiku Drake. And so the groundwork was laid with Chairperson Holiku Drake, and Chairman Watson signed the license and supported it. Okay. The important thing regarding regulatory authority in SIC Exhibit 1 on the first page, which is a July 18th letter, 1995, from Clay Nagao of the Public Utilities Commission to Mr. Chandler, is where he says that in paragraph 2, whether the PUC will exercise its authority over Sandwich Isles is a decision that the PUC will make in the context of a formal PUC proceeding. At that time, Sandwich Isles had submitted an application for a CPCN with the commission. After all of this, in that formal proceeding, the commission decided to issue Sandwich Isles a certificate of authority. Okay. And that's what we have today, which I think you folks have, so you don't need this. Okay. So Sandwich Isles doesn't have a CPCN. So the regulations under a certificate of authority are for competitive local exchange carriers. Okay. But Sandwich Isles, because it is under the regulation of the FCC, cannot be a competitive local exchange carrier. Because the FCC, as well as RUS, USDA, cannot provide funds to compete against existing carriers. That would be favoritism. And they certainly wouldn't want to do that for Sandwich Isles. So that is where this commission's authority lies. Okay. DHHL issued License 372. License 372 under the Hawaiian Homes Commission Act is for easements. DHHL doesn't have the type of authority that you have, or that DCCA doesn't even have it, where to authorize someone to do business. What DHHL has is the land, and they can limit the use of the land to just this type of business. It is similar to a zoning requirement or a land use classification. So DHHL took that right to determine how Hawaiian Homelands is used, and the right to issue easements for public utilities, and the right and obligation to rehabilitate beneficiaries like me, and put it together in a license and said, you can use these lands provided you build a telecommunications system throughout Hawaiian Homelands at no cost to DHHL and at no cost to the customers. And if you can do that and rehabilitate yourself by doing it, we grant you these lands in the form of easements. And that is what License 372 does. And it has all of those conditions. If you look at License 372, it has every one of those conditions. It is a de facto CPCN in many ways. Okay. DHHL then approved a partial assignment of License 372 was issued to Waimana Enterprises, and it covers all telecommunications. DHHL then approved a partial assignment of License 372 to Sandwich Isles Communications, SIC, for voice services only. And the reason for this is at that time, RUS, at that time is actually REA, but USDA could not issue loans for other than voice services. Okay. So it had to restrict the loan to voice services. So that is why Sandwich Isles has a certificate of authority from you that is restricted to only Hawaiian Homelands and really for voice services when it's put together with the context of the partial assignment. Okay. It was a regulatory requirement that Sandwich Isles be formed and was limited to voice. It was something that we needed to do in order to get the funds. Okay. With that, we applied for 3 loans totaling over $400 million from RUS. Okay. The first loan required that Sandwich Isles be qualified to receive universal service funds. Because RUS knew from its history with all its other loans for rural telephone carriers that until you have paid off your capital improvements, it is unsustainable. You cannot pay back these loans with revenues from the customers. And that's why USF was created. And so RUS required us to get certified by the FCC to participate in the Universal Service Fund so that we could pay back these loans. 90% of the debt service for the loans we borrowed would come from the Universal Service Fund. This is RUS's calculation. Okay? And in order for RUS to make that loan, the Secretary of Agriculture has to certify that it can be repaid. Okay? So at the time they made the loan, the Secretary of Agriculture certified that based on universal service funds, these loans will be repaid. And as I say, this is not unusual. Okay? This is what all rural phone companies sign up for. And this is what, when RUS loans money, this is what they expect as far as the bulk of the debt service coming from. It cannot, the loan, whatever infrastructure we built with those loans under the Rural Electrification Act telephone program, it cannot, those loans cannot be used to build infrastructure to compete with Hawaiian Tel. At the time, I'm sorry. There was only one other carrier, Hawtel. Okay. We could not use those loans to compete. So what RUS does is they have field engineers. You have to submit detailed engineering drawings. They send the field engineers out, and they look. And if there is sufficient facilities that is already in existence, we cannot build it. Okay. So they spent a lot of time out here looking at Hawaiian Tel's facilities that purported to be able to serve Hawaiian homelands. And their engineers said, no, it cannot. So they allowed us to build these facilities only to serve Hawaiian homelands. We received approval from the FCC to obtain universal service funds. If I could.
I'll distribute, and why don't you explain what the document is?
Okay, why don't you give me this? It's going to be these two. Thank you.
Two?
Yeah.
Is this all going to be SIC for the two?
Oh, and 2 and 3. 2 and 3.
Okay. Please.
So we'll make this one here. We'll make this one 2,
Okay.
and then the other one 3.
So I'll distribute, but please explain to everyone, so the court reporter hears what this document is.
Yes, I will. I will. So, the 2 exhibits that you will be receiving are the FCC approvals to obtain universal service funds. Okay. Exhibit 2, which up in the right corner is DA 98-166, was issued in 1998. That's the original approval to get universal service funds. Exhibit 3, DA 05-1355, is a subsequent order that the FCC issued in 2005. to continue to receive universal service funds.
Okay. Let's get it all distributed and then make sure it's marked by our clerk. Lisa. For the court reporter.
Can you? Oh, that's, that's fine.
Christian, so we're okay. I guess it's SIC Exhibit 2 is a document from the Federal Communications Commission marked DA 98-166 in the corner, right corner. And SIC Exhibit 3 is again from the Federal Communications Commission marked DA 05-1355. Mr. Boone, any objections to these items being admitted into evidence?
No objection to SICs 2 and 3.
Thank you. So they are, both SIC 2 and 3 are admitted into evidence. Mr. He, you want to continue? Thank you.
Thank you, Mr. Chairman. So these two documents, as I said, are the authorities issued by the FCC for SIC to receive universal service fund subsidies. Okay. The initial one in Exhibit 2 was issued in 1998, and Exhibit 3 was issued in 2005. And the reason that there are two is because even though Hotel did not want to serve Hawaiian homelands, they did not want SIC to get the funds to serve it. And so they opposed these, and they appealed the 98 order. And so the FCC had to go back and do a 2005 order. Okay. But in the 98 order, if you look at, and I'm sorry, I didn't have time this weekend to highlight what's important in this. But in the 98 order, it's probably helpful at this time so that everyone can understand. There are maps in the middle of the order on the
Is it marked as attachment D?
page 5 or page 6. There are maps. It begins there.
Okay. So maps of Oahu continuing on
Maui,
Maui,
Molokai.
Yeah. Okay.
These maps are the Hawaiian homelands areas. I don't know where Kauai is, but should have been. And if you look at it, you understand what we're talking about here. Because what you're talking about are areas that are remote, primarily, that there aren't a lot of telecommunications infrastructure, let alone any type of infrastructure. But in telecommunications, what happens is you connect all of it. And so when you connect all of these, the network goes across non-Hawaiian homelands properties. And because RUS came to, and that's why it's so expensive, because RUS came out here and determined that Hawaiian Tel's facilities were not able to support basic telephone service on Hawaiian homelands, we had to build a network that included it undersea cable. Okay? And so before we even got started with this, and I'm sorry I don't have this, but before we even got started with this, in order for RUS to lend money, we had to, the state needed to have a statewide telephone plan, and Hawaii did not. And so we had to create a statewide telephone plan that had to be accepted by the PUC. And that statewide telephone plan forced the PUC to stop allowing Hawaiian Tel to provide party line services because the statewide, the federal standard at that time was not party line service. Okay. So the FCC came out with the 98 order. They allowed us to qualify to get USF. Hawaiian Tel appealed it. In this order, it covers two areas: unserved areas of Hawaiian Tel and of Hawaiian homelands, and underserved areas of Hawaiian homelands. Okay. And this is important because when the rules were changed, when the PUC, the FCC changed the rules, which required obtaining an ETC, an eligible telecommunications carrier certification, normally from the State Public Utilities Commission, but in the case of tribal areas, which is what Hawaiian Homelands is considered under these regulations, the Hawaiian Homes Commission could actually issue it. You need to get an ETC for unserved and underserved areas on the 98 Act. Okay. In 2005, and we did get it. In 2005, when the FCC took up Hawtel's appeal of the 98 order, and now they had before them engineering drawings of the total state network that we were going to build, that RUS had approved, that would cost $400 million. The FCC issued its 2005 order, which is Exhibit 3, DA 051355. And in this order, they did a couple things. The first thing they did was they changed the areas that Sandwich Isles could get universal service funds to only unserved areas. Okay. And the next thing they did was they approved our spending the money, the $400 million, to build this statewide network. Okay. The importance of those two items in the 2005 order is under the ETC regulations, 47 USC 214E, Section 214E. Can you look at this? Good. If you don't mind. I'm sorry, Lisa. I'm really sorry.
Yeah, no problem.
Yeah. Exhibit 4?
This was the first one, right? I
Yeah.
think
Go ahead. You can take that. Yeah.
and this would be 4.
Okay, just to clarify, Mr. He, you're moving what will be marked SIC Exhibit 4, which is, I guess, a portion of 47 USC Section 214E as in Eric, provision of universal service, and subsections 1, 2, and 3, correct?
Yes. And I only did this for clarification. I mean, you could do it on judicial notice too, but it's a
Okay.
statute.
Oh,
Right.
any objections,
Uh,
consumer advocate?
Chair, no objection, subject to the consumer advocate's ability to check that this is the current version of this particular provision.
Mr. He, do you know?
I don't object to that.
No, but do you
Oh.
know if this is the current or this was at the time?
No. I got this off of Google yesterday.
Okay,
So,
so it might be, okay, so subject to check,
yeah, subject to check. Right. It's fine.
all right. We'll admit this as SIC Exhibit 4.
So, getting back to Exhibit 3, which was a 2005 order. Oh, I'm sorry. Anyway, the FCC 2005 order said you only can have it for unserved areas. Okay. And then if you go to, in order to get it, you have to be an eligible telecommunications carrier under 47 USC Section 214E. And if you look at the highlighted portion, it says, for unserved areas, it's by law. We no longer have to come and get approval. Okay. The second part that was very important in the FCC's 2005 order is that, like other regulatory bodies that have to determine rates, consumer rates, a utility has to go to that regulatory body before it can start spending capital improvements. So that, because it will be included in the rates. So the 2005 order, the FCC had the complete statewide network that RUS agreed to fund, had all of the engineering drawings, all the environmental certifications, and all of the impacts that it would have on universal service funds, and they approved it. They said, go ahead. Okay. So that is why it limits. The FCC really has the regulatory control over SIC. It sets the rates. It determines how much universal service funds it will allow so that the customers won't have to pay more than urban areas. It does everything that you do for a state utility. Under the 96 Telecommunications Act, they do have a carve-out for state commissions. And there is an allowance for each state to form their own universal service fund. And if the state does so, then you would have the regulatory authority to determine how that is used. But because Hawaii, like most states, did not form a state universal service fund, your authority in regards to rates for SIC is delegated by the FCC through approval of an ETC. And the 2005 order basically said there is no need for your approval of an ETC because the only place that they are serving is unserved areas, and that's the 214E. So we went ahead, SIC went ahead and started building this network. It costs more than 400 million. We actually ended up only borrowing 100 and I think somewhere around 180 million from RUS, and the rest was raised commercially. But it was based on, we only built what the FCC approved. So the network is used to only serve Hawaiian homelands. Remember, under the FCC rules and under RUS rules, we could not use this network that we were building to serve outside of, to compete with Hotel. We couldn't use it. Okay? And so we didn't. Our focus was build this because I have relatives. Most people who are part Hawaiian in Hawaii have relatives that are sitting on Hawaiian homelands without a telephone. And that's where our focus was. Okay? If you ever get into it or you have the interest in it, you will see that on Oahu, we have had plans approved by the FCC and RUS to run trunks between Waianae, Nanakuli, Kapolei, Muiliili, right out to Waimanalo, up to Waihole, every place that Hawaiian Homelands exists. These trunks, obviously, are very valuable if you want to serve the areas in between. We didn't build the trunks to do that. We haven't built that section yet, but we have the plans that were approved. I didn't want to get into a situation where Hawaiian Tel would be saying, you're using federal monies to compete with us. No. We're just trying to serve Hawaiian homelands. Okay? And that's why that certificate of authority that you issued is for only Hawaiian homelands. SIC cannot serve off of Hawaiian homelands. I asked for that restriction because I did not want to get into a public relations debacle of why is this guy using federal funds to compete with Hawaiian Tel. Not happening. We're trying to provide adequate service for Hawaiians living on Hawaiian homelands. Now, fortunately or unfortunately, the time that we started building this, telecommunications technology changed dramatically. And when we started doing it, there were copper lines. And within very few years, there were fiber lines. And San Giles actually deployed fiber to the home on Maui to Hawaiian homes. We didn't make a big deal out of it because we did not want to get into a media fight of why does a Hawaiian sitting on Hawaiian homelands have fiber to the home and I'm sitting in Kailua and I don't. Okay? We're just trying to serve Hawaiian homelands. Technology changes. Voice is delivered over fiber now. Okay? We put in what the government allowed us to put in. The government being RUS and the FCC. Other areas of Hawaiian homesteads are too remote. They don't have water, electricity, they don't have roads. Okay? Those areas, we put in copper lines because a copper line carries electricity in it. So they can answer the phone without having electricity in their home. They can make the 911 call without having electricity in their home. All right. We put the infrastructure underground to protect it from natural disasters like the Lahaina fire. Half a mile from the center of Lahaina is a Hawaiian Homelands community, Leali'i. We serve it. Well, we did serve it. We put in the infrastructure. It's underground. That infrastructure has fiber. It needs electricity. As soon as Miko turned on electricity in Lahaina, they were online. They had full service. They had internet, everything. Okay? That's why we built it underground. If I could, I'll give you two other exhibits. This one. This one.
This is gonna be 5 and this
Okay.
is 6.
Yeah, that's fine. I'll mark it.
Let me dispense with these exhibits and then do a time check since we're getting close to the lunch hour.
I can stop anytime. Yeah. Exhibit 5 is a Hawaii Business article. Oh God, what's the date on this thing? I think, yeah, you can, yeah. It was April of 2001. And Exhibit 6 is a flyer, and I'm sorry, there's no date on it. It's a one-page Sandwich Isles communications. It tells the history of Sandwich Isles.
Okay. So, the excerpts from Hawaii Business Magazine's April 2001 will be SIC Exhibit 5 and a one-page flyer titled Sandwich Isles Communication Incorporated, providing history, testimonials, is SIC Exhibit 6. Any objection from the consumer advocate?
Chair, no objection to 5 or 6.
Okay. So these are admitted into evidence. Let me just do a quick time check. Mr. E, how much longer do you have to
Testimony? I'd say an hour and a half.
Okay. So why don't we do this? Let's take a break for lunch. But before we go to lunch, why don't we get all of your exhibits,
Sure.
what you might be using in already, so that
There's probably gonna be a couple videos.
yeah,
exhibits.
that we have
We'll
a
deal.
way to deal with that.
Okay.
But any hard copy exhibits, maybe give that to us now, and then we'll
In the order that
yeah, in the order you want to present it to, right? So.
Okay.
So get that in to us, and then we'll mark it during lunch, and we'll come back and dispense of those exhibits, get them into the record. All right, so
Why don't we do,
why don't we take a break for lunch? Please come back here by 1 o'clock, 1 p.m. maybe a few minutes before that so we can get all settled in. And then we'll continue with SIC's direct testimony on this. All right? We're recessed for lunch. We are back from the lunch recess, and I believe where we left off, we had admitted SIC's exhibits 5 and 6. But in the interim during lunch, we've asked SIC to provide all of its exhibits at this time so that we can move them in. So I believe we all have copies of those. Let me just go through it. SIC Exhibit 7 is a reprint of an article from the Honolulu Star Bulletin dated July 20th, 1999. SIC Exhibit 8 is, I believe, an article from Deseret News, New York Times News Service, published November 28, 1996, entitled Rural Hawaiians Taking on Phone Giant. Exhibit 9 is in PUC docket 2022-0218, SIC's answer to complainant's reply. SIC Exhibit 10 is also from PUC docket 2022-0218, and that is SIC's objections to proposed findings of facts and conclusions of law. And SIC Exhibit 11 is excerpt of 47 USC Section 251 interconnection. And it's items subsection F, subsections 1 and 2. Okay, that's the items that I have, so it's numbered 7 through 11. Consumer Advocate, any objections to those being moved into evidence?
No objections, but a couple clarifications.
Sure.
So for Exhibit 11, that's subject to the same check that we raised earlier regarding the
Yes,
date
the
of the
previous.
statute.
Sure.
And then for Exhibits 9 and 10, I note that those were, they have a signature block for Mr. Albert He. Exhibit 9 stated March 12th, 2024. Exhibit 10 stated February 20th, 2024. And I guess we would ask if the same colloquy could be done of Mr. He to ensure that he was authorized to speak on behalf of SIC for those two documents, or just clarify that before they come in. Because based off the history, it's my understanding that he wasn't president of SIC until very recently, and likely before the dates of these documents.
Sure. Mr. He, do you want to clarify those items?
Consumer Advocate is correct. I was not the president, but I was authorized by the then president to represent SIC in that docket. And SIC did not have counsel in that docket.
Okay. Yeah. You want to bring that up? Commissioner Kuai.
Mr. Hiei, my understanding is the two documents identified as SIC Exhibits 9 and 10, that those two filings were made after the hearing officer made his decision in 2022-0218 and are therefore untimely. So
We
they're-
were not allowed to participate in that hearing. SIC was not allowed to participate in that hearing. So, the
Well, you
the hearings officer made a recommendation. I responded to that
But
record.
they're not officially part of this record, of that particular record. So are you trying to bring it into this particular proceeding, even though it was deemed it was not formally accepted into the other docket?
I'm not sure you're of the legal procedures. However, obviously SIC was a party to that docket because the docket title is Hawaiian Tel versus SIC. But we were not allowed to participate in the hearing. So when the hearing officer came out with his proposed findings of facts and decisions of law, I submitted and I think it's 10, I don't think it's 9.
9 and 10?
Objections.
Yeah, but the first one that went in was 10. The hearings officer had already closed the hearings, and I submitted that. And then Hawaiian Tel's attorney responded to that objection, and I submitted an answer to Hawaiian Tel's attorney's. I guess they titled theirs a reply to my objection.
Consumer advocate, based on that discussion, do you still have concerns regarding its admissibility? Or
To
any
the extent
objections?
Mr. He is adopting both 9 and 10 as his testimony today, the consumer advocate won't be objecting. And we'll just leave it at that. We'll defer to the commission on admissibility or whether or not they're timely in docket number 2022-0218.
I just also note that that docket's still open and pending before the commission, so to the extent this is introducing any new arguments related to that, it's not appropriate here. But in terms of just for purposes of his testimony, as long as it isn't doing that, we can see where it goes.
With that, Mr. Chair, I recommend that we allow in the remainder of the exhibits with the caveat that with respect to exhibits 9 and 10, it just reflects Sandwich Owl's testimony with respect to today and not reflective of dockets 2022-0218.
All right. I'll accept that recommendation. And so SIC exhibits 7 through 11 that were previously identified will be admitted into evidence. All right, so we left off, I know, Mr. He, you introduced exhibits 5 and 6, and I believe you said you had about an hour and a half
Yeah.
to go. We will provide you that time.
Okay.
But I do want to make sure that, and I know, you're trying to provide the history and leading up to why we're here today, the reason why we're here today. But if you can tighten up that testimony, I would appreciate it. I think everyone would appreciate it. Because we do have, probably the cross-examination thereafter.
Thank you, Mr. Chair, and I will try to do that. Although I termed it as a history because it is, that's when the authority of this chair, of this PUC actually was decided. And that's why it's necessary to go back 30 years, because that was when the authority of this PUC was decided. Okay. So back, as I had introduced in the previous exhibit, which was a letter from Exhibit 1 from Mr. Watson to Chairman Naito. He said it was their intention at that time in 1995 that Hawaiian Homelands would be served by SIC and not by GTE Hawaiian Tel. The Exhibit 5 is an article that came out in 2001, 6 years after Mr. Watson's comments. And it gives the progress that Sandwich Isles was making toward Mr. Watson's desire, stated desire, that Sandwich Isles be the telecommunications provider for Hawaiian Homelands. You know, there are other things in here, but in the interest of brevity, I'll try to, you know, there's a picture in there of, on page 19, of this barren area with these reels of cable right below the map. And those are the kind of people that we're trying to serve. That is indicative of Hawaiian Homelands. That is what Hawaiian Homelands wanted to give out. The map itself is a map of what was approved by both RUS and the FCC. Okay, and you see there are two inter-island cables. Both of those were approved by both RUS and the FCC. But it is not what we built. If you can see, the areas of Hawaiian Homelands are in yellow. And you can see that connecting the areas of Hawaiian Homelands would entail a network that was approved by both RUS and the FCC that would transit many of the areas that are not Hawaiian Homelands. The Exhibit 6, which is just a history, a one-page history of it. There again, we had come to, there is a testimonial by a subsequent chair of Hawaiian Homelands, Mike Akane, that is supportive of what we were doing. So it just points out that we were doing what Hawaiian Homelands wanted us to do well into the 2000s. Okay. While we were doing this, I will tell you that I was getting major pushback, political pushback. Former Governor Lingle, while supportive of SIC, made it known that she thought spending $400 million to help Hawaiians was too much. Okay. And former Governor Ige, a former Hawaiian Tel employee and lobbyist, provided funds to DHHL for DHHL to petition the FCC to start dismantling what they had approved in the 2005 order as far as USF. And then we come up to the May 20th auction and what it meant and why we have gone to termination of service. So up to then, what we were doing was we were doing exactly what the regulatory bodies had told us to do. DHHL wanted one provider because Hawaiian Tel had proved to be not willing to provide throughout Hawaiian Homelands. They wanted one provider. We came up with a way to do it. We actually offered it back to DHHL. I wish they took it because I knew what it would mean. And DHHL declined and said, no, we want you to take the risks. We want you to provide this service. And so we did it. And we got very good support going forward. Okay. So given the change in regulatory / political attitudes, there were many efforts, or I won't say there are many, the efforts of Hawaiian Tel that began with our first order in 1998 from the FCC, when they objected and did not want that order passed at the FCC. Those efforts that began back there started to bear fruit. Okay. and they started to dismantle the underpinnings of Sandwich Isles' ability to provide service to Hawaiian homelands. Once you as you well know, as a regulatory body, once you are able to stop the utility from getting funds necessary to continue service, you basically put the utility out of business. And you folks were not a part of it because you didn't have the direct authority for these funds. These funds were coming from the FCC. So on May 20th, as part of unwinding this, or the May 20th auction, as part of unwinding all of this, RUS and Sandwich Isles agreed on a auction for the remaining assets of Sandwich Isles. We insisted that the auction procedures include a provision whereby whoever won all of this infrastructure would continue to serve Hawaiian homelands and those customers that SIC had. This is not only a desire by us, it is a requirement of the Hawaiian Homelands license for the easements upon which all of these assets are built. Okay. RUS agreed. There were two bidders, Hotel and Waimana. Hotel specifically excluded providing service to SIC's customers. They wanted to buy all of the conduits. No customers, no last mile, even though that was a requirement of the bidding procedures. Their condition was that SIC continue to provide service under the Certificate of Authority. Okay. No money, nothing. But that was their condition. The FCC, in its emergency order, or whatever order it was, said, not only will you have to continue service, you have to allow a hotel to steal all your customers while you're continuing service by porting those numbers. No money, nothing. Okay? So we were faced with a pretty stark future. We were essentially a utility without the ability to fund the services that it was being ordered to provide. Okay. And it was being done by the FCC and by DHHL. Okay. So we found out we couldn't do it. And so we ended service. Okay. Waimana's bid said it would continue to provide service. It would have clear title to all of SIC's assets. It would be able to enforce docket 2022-0218, which is currently open, but under which Hawaiian Tel is currently using SIC's conduits and its lines, as well as putting in their own infrastructure to SIC's customers without a license from Hawaiian Homelands. If Hawaiian Homelands had issued them a license, as they issued to Waimana and to SIC, we think that the license would have the same obligations that SIC's and Waimana's license is, which is you serve one, you serve all. Carrier of last resort. But because DHHL has made a decision that they wanted to now support getting rid of dismantling SIC, they allow Hawaiian Tel to serve on Hawaiian homelands without a license. Complete violation of the Hawaiian Homes Commission Act. They allow Hawaiian Tel to take revenues that SIC needs to continue to serve its customers. Complete violation of Hawaiian Homes Commission Act. Outside of your jurisdiction, unless those are part of what has been ceded to you. I don't believe, even if it was ceded to you, I don't believe that they could cede a authority to violate Hawaiian Homes Commission Act. Okay. So it's a mess. It's a mess. It's a very big mess. The authorities under which we built SIC have been dismantled by the two agencies that gave us those authorities. And they dismantled it over the FCC over 10 years, DHHL over the last, 6 years. And during this time, we have continued to provide service because that is my family that is sitting up there on the mountain that needs a phone. Okay? And that is my family that is sitting there whose children are being taught using SIC's internet. But we came to a point where we could no longer do it. We had hoped that the auction would do exactly what we had agreed with RUS, that if somebody else wants to do this, please do it. But this is an essential service. This is safety. This is why we got into it. If somebody wants to bid for that, please do it and continue. And what we got was the government saying, Hotel, you win. You can have all of the infrastructure. You don't have to serve any Hawaiians. So now we've returned to 30 years before, when Hotel said, we don't want to serve the Hawaiians because we don't have the infrastructure and it's too expensive. And so Hawaiian Homelands looked at me and said, can you fix it? So I fixed it, and I built the infrastructure. And I only served the Hawaiians. I didn't go outside and compete with Hotel, because that was restricted. Okay? I only served the Hawaiians. And now Hotel has found a way to take the infrastructure without serving the Hawaiians. So we're back 30 years ago, where it comes down to, they don't want to serve the Hawaiians. 30 years ago, there wasn't the infrastructure. Today, the infrastructure is there. We still don't want to serve the Hawaiians. I don't know. Okay. So, in regards to the cease and desist, the Supreme Court has clearly established that a utility cannot be forced to provide service at confiscatory rates. We have confiscatory rates, not through any action by this PUC, but through actions by the FCC. And we have been dealing with the FCC, as you saw in the attached letters to the subpoena from Mr. Smith to the FCC. That goes back many, many years. Mr. Smith, representing Sandwich Isles, had been going to the FCC to try to figure out how to deal with this back in 2015, 2016, 2017. We reached tentative agreements. They backed out of the agreements. I mean, I could fill up this room with the historical documents. And finally, the last time Mr. Smith had set up a meeting with the FCC, flew up there to meet with them. The FCC canceled it. No reason, just canceled it. And that's the last we heard from the FCC until this porting order. Okay? We have been trying to work with the FCC. If you look at the letter, and that's attached to the subpoena, Mr. Smith sent the last letter to the FCC 31 days before we cut service on May 8th. Right? So the FCC, which is the regulatory body that sets our rates, was well aware of what would happen at some point in time, that we would run out of money. They were well aware of this 10 years ago. They were definitely aware of it 5 years ago when they cut off meetings, and they were given notice 30 days before we actually cut service because of your cease and desist. Because we extended it for another week. So it happened after the 30 days after that date of that letter to the FCC. Hawaiian Homelands. I have been going to the Hawaiian Homes Commission meetings, and I'm happy to show you a video if you want, where I have been pleading with them for 3 years to resolve this issue because service will be cut off. Okay, so if anyone thinks that this is a surprise to Hawaiian Homelands, you are badly mistaken. I got relegated to only being able to appear at Hawaiian Homes Commission meetings as a member of the public. I was given 10 minutes to make my case, and I have videos of me trying to make my case. This Hawaiian Homelands and the FCC decided the best way to end License 372 and the obligations to serve Hawaiians on Hawaiian Homelands was to not respond. And this decision apparently was made several years ago and continues to today. Okay. We have put in the record letters and emails from myself to DHHL pleading that this is not good. Let us work with you, and getting no reply. Okay. So we are a utility that is being forced to provide service without compensation at rates that are confiscatory. And the Supreme Court has said, can't do that. That's a taking. We have filed taking claims with the FCC. It has gone through the Court of Federal Claims, who said they didn't have jurisdiction. It went to the Federal Appeals Court, who said you need to file with the FCC first. It has been filed with the FCC. We have not heard from them. Let's see. What are I doing here? Exhibits 7 and 8, which is about Tel Hawaii. In 1995, about the time that we were getting started, the legislature passed a law which allowed limited competition in areas that were not adequately served by Hawaiian Tel. The PUC held hearings. They selected a company, Tel Hawaii, to provide service in Ka'u. Again, even though Hawaiian Tel didn't adequately serve them, didn't want to serve them, they objected. And they held many hearings before the PUC at the time and took Tel Hawaii to court. At the time that the PUC interpreted its law authorizing this, it was interpreted as an exclusive license to serve that area. That was necessary, just like the license that I had to get the federal funding to be able to build out the infrastructure. Tel Hawaii did that. The PUC subsequently changed that order from exclusive to unexclusive. And then they ordered that that Hawaiian Tel turn over its infrastructure to Tel Hawaii. And they fined Hawaiian Tel, I think it was $10,000 a day until they did it. Hawaiian Tel subsequently appealed, went to the Hawaii Supreme Court. The Hawaii Supreme Court found it was a taking because they took Hawaiian Tel's property this time and gave it to Tel Hawaii. Had it been remained an exclusive right to serve in that area, it would not have reached the courts. Yeah. So this one here, now Exhibit 7 is the one from the Star Bulletin. And it's dated July 20th, 1999. State regulators approved its plans for Tel Hawaii for entering the market, yet failed to defend those approvals when GTE Hawaiian Tel challenged them. Okay. Tel Hawaii pulled out, saying the present regulatory and political considerations in Hawaii are not conducive to Tel Hawaii's continued attempts to serve and provide Hawaiian telephone customers. This other one talks about, this Exhibit 8 talks about the PUC's action and GTE's court filing, which they eventually won, which led to the taking. So we're on the, if I understand this proceeding, we're on the cusp of, well, actually your cease and desist order and the FCC's order basically takes SIC's property and forces us to serve at confiscatory rates. SIC has been able to serve since the FCC reduced and then eliminated USF, because the business plan that SIC put together was Hawaiian Homelands offered a unique opportunity to build a self-sustaining telecommunications network. It would be unlike other rural areas, it would be self-sustaining because other telecommunications providers would want to use some of the facilities that SIC built. SIC was prohibited from using those facilities that other telecommunications providers wanted. And by regulations, we were prohibited from using it. And so we didn't. But once those facilities and those loans were paid off, and we stopped taking universal service funds, we would no longer be prohibited. And we would be able to allow Hawaiian Tel, Spectrum, and any other telecommunications carrier to use those facilities to improve their service to their customers. And the revenues from that would be more than enough to continue to provide service to every Hawaiian on Hawaiian Homelands. Okay. We have been able to do this because we did not have to pay the debt service while the litigation was going on. and we were making ends meet on operational and maintenance with the revenues that was generated within SIC. When Hawaiian Tel filed their complaint with this commission in docket 2022-0218, saying that we had to interconnect and going ahead and using SIC's facilities and easements without permission from DHHL, it deprived SIC of the revenues it needed to continue to provide service. Docket 2022-0218 is still open. It was opened 4 years ago, I believe. Under the federal statute, which I think is Exhibit 11, there is an exemption for companies like Rural Telephone, like SIC. That exemption says we don't have to interconnect. That exemption is a purely economic exemption. It is the same reason, just as we cannot use our facilities to go and compete with Hawaiian Tel. Hawaiian Tel cannot come in and force us to let them use our facilities to compete with SIC. It's a simple notion. Okay? It's a throwback to the monopolies. Okay? This was an integral part of the 1996 Telecom Act. The 1996 Telecom Act deregulated telecommunications because the government correctly felt that competition would lead to innovation and to lower prices. The government also said there are areas in the country that competition is not possible, and we need to ensure that those Americans living in those areas are afforded robust telecommunications. And thereabout came about the USF, Universal Service Funds. It is a subsidy to subsidize those areas. It is not unlike in 1979 when the federal government deregulated the airline industry. Congress established the Essential Air Service Program to ensure that small airports continue to receive service and that citizens living in those areas could get out of those airports. Hawaii has 2 airports currently receiving subsidies, Kamuela and Kalaupapa. Lanai is now up to continue to get subsidies and is being bid for. This program is funded by fees on airline tickets. It's $18 billion a year. The USF program is funded by fees on telephone bills. It's $8 billion a year. What is happening here is not unlike history that has occurred. There are many, going back to the 1800s, examples of government siding with capitalists to destroy Native American businesses. Cherokee Nation versus Georgia in 1831. Cherokees in Georgia on their reservation became very adept at business. Georgia wanted to destroy it. They did. They rezoned it, et cetera, et cetera. It went to the U.S. Supreme Court. The U.S. Supreme Court said, no, you can't do that. The president refused to enforce that decision. The Cherokees were forced out of Georgia and now live in Oklahoma. The Osage Nation in Oklahoma in the 1920s, when the oil boom was going on, their reservation had mineral rights, oil boom. They became very prosperous. They lost it all. Keeps Eagle versus Vilsack, 2000. This involves the U.S. Department of Agriculture, the same secretary under which I have these loans. This was loans made to Native Americans for farming. Rather than fight it in court, the Department of Agriculture resolved the claims of their systematic discrimination against Native American farmers and ranchers in how they administered its loans programs. And they settled this for, I believe, $800 million or somewhere around there. There's been a number of cases locally documenting the use of Hawaiian homelands for non-Hawaiians by the Hawaii Supreme Court, dating back 20, 30 years. The latest being Kalima versus DHHL in 2012. Prior to that, you had Hilo Airport. Hilo Airport is on Hawaiian homelands. The state took it, built the airport. The state eventually settled that because they weren't supposed to do it. And it violated the Hawaiian Homes Commission Act. And the Hawaiians protested it, went through court. The state settled. Okay. The state claimed that because Hawaiians also used that airport, they were justified in taking that land. They settled. The county of Hawaii used Hawaiian homelands to build their sewage treatment plant in Keaukaha. They moved it. Okay. So taking land, and there are Hawaii Supreme Court cases, taking Hawaiian homelands for, quote, the public good over the good of Native Hawaiians has been struck down. Okay. But I'm not here to do this. I'm here to make sure that Native Hawaiians have telecommunications. That's all I started out to do, and we did it. We did it well. It was going to be self-funding after, it'd be another, not that long, maybe another 5 years if it had continued. It would have been self-funded. No more subsidies, right? The government dismantled it. You folks weren't a part of that, but the government dismantled it. The regulatory bodies that set up the programs that I used to do this, to set up a system where there would not be any more need for federal funds, subsidies or not. They dismantled it. I don't know why, but they did. Okay, two types of people live in high-cost rural areas: the rich and the working poor. Okay? The wealthy people, they can afford telecommunications. They got Starlink, satellite phones, personal hotspots. The working poor on Hawaiian homelands can't. They can't afford Starlink. So what do? They just accept their lot in life and don't complain. And that's where, if this is allowed to happen, that's what will happen. They will be like they were 30 years ago, without telecommunications, or at that time, without a telephone. This time, they're not going to have telecommunications. And at some point in time, they just stop complaining. And they just say, well, hey, at least I got a home. At least I'm not living in Las Vegas. Okay. So, I don't need the videos. I can use them in cross, but I think it's okay. So I'm not going to continue after this. Thank you.
Thank you, Mr. He. Mr. Boone, are you ready for cross-examination?
Chair, we are ready, and we have very minimal, if any, cross. But in the interest of time, we are also naming and intend to call Mr. He as our own witness. And for judicial efficiency, we would like to ask that we just combine the cross-examination and direct examination from our office to help speed this hearing up.
Sure. I think so long that you can differentiate, right, what is cross and versus what is direct, maybe that would help to make sure that the record is clean and we know where each section lies. So
Thank
if you
you,
could do
Chair.
that,
Thank you, Chair.
I'll allow it. Thank you.
And the consumer advocate filed consumer advocates exhibits 1 through 4. I believe commission staff should have copies, and I'm going to provide one to the clerk and transcriptionist.
Mr. He, do you
Yes.
have a copy of,
Yes, they provided it to me. Thank you.
do you have any objections to those items being admitted into evidence? Consumer Advocate Exhibit 1, an email, looks like an auto reply from Sandwich Isles, that was
Right.
sent to,
No objection.
no objection to that. CA2 is an email from you to the parties as well as the PUC dated June 10th.
Right. No objection, Mr. Chair.
Consumer Advocate 3, which appears to be a letter to myself, addressed to myself, dated June 1st, 2024.
No objection.
And Consumer Advocate Exhibit 4 is an email from you to Kali Watson and Beatrice Burr-Luwanu, dated June 10th, 2024.
No objection, Mr. Chair.
Okay, hearing no objections, Consumer Advocates Exhibits 1 through 4 will be admitted into evidence.
I'm sorry, Chair. I just want to confirm. So CA4 does include several documents lumped together.
Sure.
And I just want to confirm SIC is not objection to pages
No
1
objection.
through 6.
No objection.
To the packet. Okay. All right, thank you.
So, Mr. He, are you okay if I refer to Sandwich Isles Communications Incorporated as SIC for the purposes of this, your witness testimony today?
That's fine.
Okay. And this is part of our cross-examination, but earlier you mentioned a May 20th auction in which SIC's assets were auctioned off. Is that correct?
Yes.
To your knowledge, has the sale of those assets been approved by court order?
No, it's been, the motion for confirmation was made, and there was a procedural thing set up for it. And I don't know the dates.
So, motion to confirm, does that mean that a court has to approve the sale before it's final?
Yes, I believe so.
And your testimony is that hasn't happened yet, correct?
Yes, it has not happened.
Okay. Going to go a little out of order here, but if we can start with CA2. Yes. And this has already been admitted into evidence, but can you confirm that you wrote this email?
Yes, I wrote it.
And do you adopt it as part of your testimony today?
I wrote it. I don't know what that means as far as adopting it as testimony, but I wrote it.
I'm going to give you some time to review the document. And please just let me know when you've gotten a chance to read it over.
Okay?
Is there anything you disagree or would like to amend with respect to this email?
No, I think I sense that I'm going to have to explain some of it, but I certainly don't disagree with anything that has been said or that is said in this.
Earlier, you testified that all of the SIC employees, except for yourself, were let go as of June 1st. Is that correct?
I'm not sure what the date was, but yes, they have been let go. There was a lot of things happening the first week of June.
But that was your prior testimony, correct? June 1st?
If that's what I said, then that's what it was. I do not recall specifically the date.
Do you recall if it was before or after the commission issued its order to show cause?
I believe, I do not recall.
Okay.
I don't have it. There was a series of emails between myself and the Department of Justice leading up to between May 24th, when they finally allowed us to see the results of the auction. Actually, I'm sorry. Between May 20th and May 24th, after the auction occurred, and May 24th, when we were allowed to see the results of the auction, in which I told DOJ that we need to understand what's going on because we have customers we have to tell what will happen because of the auction, and we have employees that we have to notify that they may be losing their jobs. So the process of informing my employees actually, again, like all of these other notifications, it didn't just happen after the cease and desist. It didn't happen 30 days before the cease and desist. It happened years before. And specifically to my employees, I have had employee meetings with them almost monthly, in fact, probably monthly for the last 6 months, saying we are coming to a threshold. And I cannot predict what the threshold is going to be, but it may not be good. And so trying to give them as much time as possible to deal with the terminations. So, yeah. So, I mean, you're trying to keep this into a context of a week. And I'm saying this crisis is this 1 week crisis is a result of many, many years and many, much correspondence with all involved.
You also previously stated that, again, it's around that June 1st timeframe, SIC had about 25 to 30 employees at that time. Is that
I
correct?
believe so, yeah.
And is that, does that represent SIC being fully staffed, or were there more employees prior to this?
SIC at one time had 100 employees.
Can you give the,
Thereabouts, I don't know exactly.
so approximately 100 at the peak. dwindling down to 25 to 30 in the June 1st timeframe, correct?
Yes.
Can you give the commission a sense of how SIC gradually got from 100 to 25 to 30 employees?
Lack of funds.
Can you give the commission an understanding of the timeframe that attrition would have happened?
That attrition would have happened over a period of, my best guess is 5, 6, 7, 8 years. As the FCC started to cut back on the universal service funds, we started to reduce our costs dramatically at first and then gradually as it continued on. But we always had the hope that the FCC would restore the funds. And so that's why I say this issue of finally terminating service has been something that was started a decade ago when we started seeing funds dry up. And as as courts have made rulings, et cetera, it has worked both against us and for us in regards to continuing service and how much funds we had to have available on an ongoing basis.
So in the last calendar year, since January of 2024, has your employee headcount remained steady at that 25 to 30 number, or?
Somewhat, and then, and like I say, I apologize, but when we, this Hoy business in 2001, that was when we were fully staffed. I had many people that knew all of these details. That's why today I can't tell you how many employees we had. I was not an employee of SIC. Bob Kihune was the CEO. He did the daily meetings. He did all of the decisions as to the number of employees, et cetera, et cetera. I was the president, but I didn't get involved in the day-to-day. So I don't have the details that I think you're looking for. I can give you generalities in numbers. I can give you generalities in dates, but I cannot give you those details.
Thank you. Are you familiar with the email account info@sandwichisles.com?
I am. I do not read it, but I am.
What is that email account?
That account, my understanding of that account, it was set up again when Sandwich Isles was fully staffed, but that account was to allow information or to encourage a free flow of information between customers, vendors, and Sandwich Isles.
And again, to the best of your knowledge, when SSC was at full operational strength, do you know how that email account info@sandwichisles.com was being monitored?
We had customer service employees that monitored it consistently, and we also had network service technicians that monitored that, as well as another general email account that was specific for technical problems. And we had, and it was also monitored by their supervisors and at times Bob Kihune.
So,
I'm sorry?
Bob Kihune, Kihune. The
So-
CEO. I'm sorry, Scott.
that's fine. So when SIC was at full operational strength, you mentioned customer service employees would monitor that account. Do you know approximately how many would have been monitoring it?
How many employees? Gee, at one time, our customer service employees numbered 5 or 6, not counting their supervisors.
And then if you were to count supervisors, do you know approximately how many total that would have been?
No, I won't even hazard that guess.
Okay. Same question, but for,
You want me talking to the mic? Got it.
when you got down to that downgraded status, I'll just call it, where you had 25 to 30 employees, how many customer service employees did you have at that time monitoring the info@sandwichisles.com account?
We worked our way down to 2 full-time and 1 part-time. And if we needed to have somebody else get involved and help, they got involved and helped. But 2 full-time and 1 part-time.
So is it fair to say going from that 5 to 6 to that 2 full-time and 1 part-time, did that degrade SIC's ability to really monitor that main email account?
No, I don't think it degraded our ability to monitor it. The PUC had set up metrics on customer response to customer complaints, and we were always well under it. Like any utility, you're going to have complaints. Well, what you find is your complaints are generally in 3 categories. You have a disruption in service, you have a new customer, or you have a chronic complainer.
Thank you. Can you confirm if a customer needed to terminate their service?
To terminate?
Correct.
Okay.
Let me just repeat that. If a customer needed to terminate their service, could they communicate that to the info@sandwichisles.com email account?
They could, yes.
And similarly, if a customer needed to stop an automatic bill payment, could they communicate that to info@sandwichisles.com?
They could, yes.
Was there any other method of communicating that to SIC? Those two things?
Yes, they could do that. They could also call. There was another technical line there. And they can email, obviously, both of those additional ones. The technical as well as just a general. No, go ahead.
I'm sorry, can you clarify? So there was a phone number customers could call to either terminate service or stop their automatic bill pay?
Any one of the methods of contacting Sandwich Isles was available to any customer if they wanted to, for any reason. So the technical lines, even though they were set up for technical problems, would also receive termination requests, as well as requests for service. So as long as you could get a hold of us, we could deal with it. It would get to the right person.
And so that technical line, can you walk us through the same staffing for that line, going from when you're fully staffed at around 100 employees down to the 25 to 30?
I would guess the technical, the number of technical or technicians at one time was probably 20 or more. Not all of them were, most of them were in the field. Not all of them were monitoring phone calls, but they were all available to deal with those things. Until today, you got 6. It went down to 6.
But you don't know how many of those would be monitoring the line at any given time?
At least 2 would be,
And that's when you were fully staffed or currently?
not currently, but before we terminated, yes, at least 2.
I'm sorry, so that's when you had 25 to 30 employees, correct? Now, how about when you had 100?
I thought I said whatever number I gave you, 25 or something.
Thank you. So just for my understanding, is it your testimony that 25 individuals were monitoring your technical line?
No, that's not what I said. I said, you asked me how many people were available to deal with it, or at least I understood you to say that. And I said at full strength we had 20 to 25 technical people, any one of which could work on a termination and or start of service. But they were mostly in the field. They were not answering phones.
Thank you, and I apologize. So let me rephrase that question. What I'm trying to find out is how many individuals you had assigned to monitor the technical phone line at any given time. So if you could please, to the best of your knowledge, provide how many that would have been when you were fully staffed at 100 employees, and then when you were staffed at 25 to 30.
And as I said, when we're fully staffed, I didn't get involved in the day-to-day operations. I didn't do the hiring. I didn't set the schedules. I didn't do any of that. So I don't know that specific. I can answer these questions in generalities because I was briefed at least once a week on what was going on. But if staffing was not an issue in that briefing, I don't know I was briefed on the problems. If staffing was a problem, they'd brief me. I do not recall being briefed very often, if at all, on staffing issues.
If we could please turn to Exhibit CA1. And do you recognize these documents? It's 2 pages consisting of auto replies from sandwichiles.com.
Yes.
Did you draft these messages?
I saw these messages and probably had some suggestions to it, but it was drafted by, or it was passed around to a few people. But I'm the final say to it, yes.
And do you know, are these auto reply messages generated when an individual would have emailed info@sandwichiles.com?
I believe so.
Do you recall when this automated message was first established?
It would have been sometime after June 7th or June 8th. I'm somewhere around there.
And has this automated message remained in effect since June 7th?
Since it was instituted, yes.
Thank you. Let's move to CA3. This is a public comment filed on June 3rd, 2024, in docket number 2024-0164. And on page 4 of the document, it is, page 3, it is electronically signed by an Albert He. Do you recognize this document?
Yes.
And this was submitted as a public comment, but did you write this letter?
I wrote it. I actually meant it to submit it as part of this proceeding, but I didn't know how to electronically file at the time.
No, thank you for that confirmation. If you could turn to page 3 of CA3.
Is that the last page of the letter, or is that,
Yes, in the top right, there's page numbers.
oh, I got it.
Okay. So looking at the first full paragraph, first sentence, you state that, quote, service to rural HHL has always been a safety issue. Can you confirm what you meant by HHL there?
Hawaiian Homelands.
And can you tell the commission what you meant by this statement?
I think it speaks for itself. I
Thank-
mean, service to rural Hawaiian homelands has always been a safety issue.
Does safety include the ability to call 911?
Safety includes, I view 911 as a solution to the safety issue. The safety issue is being at the top of the mountain and not being able to call for help. Or to get help, I'm sorry, not call for help, to get help.
And do you agree those safety conditions persist today?
I agree that those safety conditions persist in some areas today, yes.
What do you mean by some areas?
Not all areas don't have, if you view safety as being able to get help by any means available, not all areas have the same degree of safety concerns. If I can walk out of my house and call my neighbor to get help, he has a safety issue, like his neighbor has a safety issue, but he has an ability to get help. Whereas if you are somewhere that you cannot walk and get help, then you have a greater safety issue.
Are you aware of any SIC customers as of June 9th, 2024, whose only means of communication was SIC telecommunication service?
Are you talking about only means of, you're talking about they can't walk out of their house and call their neighbor? Talk to their neighbor? I mean, communications, what are you talking about? They can't write a letter? They can't send an email? What are we talking about? Are we talking about just voice on a phone?
Let's start with just voice.
Yes, I am aware of some.
And what areas are those?
Primarily in Kahikinui, on Maui, Pu'ukapu on the Big Island, some areas of Molokai. Might be a few areas of Kauai. Now, we're talking about strictly voice, right? Scott?
So you mentioned,
Oh, wait, I have a question. Are we talking about strictly voice?
Mr. He, the question was about strictly voice, and
Okay,
I'll
I just
continue
wanted
to ask you
I
questions.
just wanted to make sure.
So you mentioned Pu'ukapu, Kahikinui, and parts of Molokai, correct?
Kahikinui,
Thank you. And parts of Molokai, right?
parts of Molokai, and possibly some parts of Kauai.
What do you mean by possibly some parts of Kauai?
Well, sandwich aisles, again, if you're looking at a safety issue, there are several ways of getting help. Voice is one. Sandwich Isles also has, or not Sandwich Isles, Clearcom, who does data, has a agreement with Spectrum to provide internet into some areas of Hawaiian homelands that they desire to provide it. So you can get help through the internet also.
So is it your testimony that you don't know whether or not parts of Kauai have that internet access?
Yes, I do not know.
And is that because you just don't recall, or SIC just lacks that information?
Oh, SIC doesn't lack that information. I lack the information. I'd have to go research it.
So before you decided to terminate service, did you research that issue?
Did I research what issue?
Thank you. Before you decided to terminate service, did you research whether these certain parts of Kauai had access to internet?
I think we're maybe this is the problem. We terminated service because we ran out of money. We didn't research anything. We ran out of money. Okay, it's like going to McDonald's and not being able to buy a hamburger. You don't buy the hamburger. Okay. So, when you run out of money, you run out of money.
So if your testimony is that you did not research anything, did you look into any of these areas to see if wireless communication was an option or cell phone tower access was available?
Again, when we terminated service, it was because we ran out of money.
In its amended response to the Public Utilities Commission subpoena filed June 14th, 2024, the Department of Hawaiian Homeland states that Pu'ukapu, and I'm going to mispronunciate this, but Kahikinui, is that?
Kahiki.
Oh, thank you. Kahiki Nui and areas of Molokai do not presently have ready access to alternative service providers. And they also mentioned Keokea.
Keokeo.
Do you agree with that statement?
I don't know where exactly in these areas they're talking about, but generally I would agree with that. Yes, I can show you a video of some of these areas and what happened when we went in and served, because those people, in fact, I should show you the video.
No, I think that's all right.
Well, if you want to cross-examine me, I'll leave it as part of my answer. I mean, if you want to know about this wireless, the availability of wireless in these areas, I can show you a video where the people who live in those areas go, "Thank God, Sandwich Isles, you came, because we didn't have connections."
Let's move to Exhibit CA4.
So do I show this or not?
Chair, I'd ask that any requests to provide, I guess, rebuttal evidence be reserved for cross-examination.
I think it's part of my answer.
Mr. Boone, are you satisfied with his oral answer as how he gave it, or?
Commissioner, I am satisfied with the answer that's been given on the record.
Okay, let's move on.
Sorry, are you at Exhibit CA4?
Nope. I am now.
And I'd like you to look at page 1 of CA4, which is an email dated June 10th, 2024, sent 7:28 a.m. Do you recognize this email?
Yes.
And it looks like the signature line is cut off at the end, but did you write this email?
Yes, it's from me. You see the "from" up on top.
And in the first sentence, you state that SIC has been forced to suspend service. Does this include voice service?
SIC is only voice.
Thank you. And when did SIC suspend its service?
I believe we suspended service on the 7th, and there are some areas that still have service because of contractual obligations. But this generally, we have suspended service, I believe, as of the 7th.
And you mentioned some areas having service because of contractual obligations. Is that part of your document production in response to the subpoena from the commission?
I'm not sure.
Okay.
Was there a document request for that specifically?
I'm just asking if it's in your document production.
I don't know.
Thank you. Okay, and then comparing pages 2 and 3 of Exhibit CA4. And I apologize because the text is very light on page 2, but I'd just like you to compare pages 2 and 3 because it looks as if these are the same messages.
Yes, it does. It looks like it's the same. I would agree with that.
And these are messages dated June 5th, 2024. Did you draft this message?
No, this one I certainly approved it. I think it was drafted. It was drafted prior to. It was drafted in preparation for what may happen. So I think other than the dates, etc., the content of the email was drafted prior to June 1st.
But as of June 5th, you were the only employee of SIC, is that correct?
Right. That's why I was the one that approved it or finalized it.
So you would have sent this message out, is that correct?
I think it's on the. Yes, I would have. I was the one who made sure this was sent out. Yes.
Thank you. And there's no email addresses in the 2 line, but can you confirm? It's my assumption this would have been sent out to SIC's entire customer base. Is that correct?
I believe so. Yes.
Again, please turn to page 5 of CA4. And again, I apologize because the text is a little light. But if you can, please review this and let me know if you recognize this message.
Yes, I recognize it.
This is an email dated May 30th, 2024, sent at 9:38 p.m. Again, did you write this message?
I approved it and had a hand in writing it.
And similar question, was this message sent out to SIC's entire customer base?
I believe so. Yes.
Okay, turning to page 6. And this one is more legible. Again, did you write this message?
I didn't write this one, but I certainly approved it.
And this is an email dated May 21st, 2024, sent at 4:07 p.m. Again, was this message sent to SIC's entire customer base?
I believe so.
In the very last paragraph on page 6, second sentence, it states that we will stop all automatic billing once we no longer provide service to you. Do you see that?
Yes.
Has this been done?
Billing, automatic billing stopped as of the end of May. And yes,
Does SIC do billing on a foregoing basis, or is it billing for the prior month's service?
it's foregoing. So we did not bill for June.
Okay. And just to confirm, based off this email, SIC has the power to stop automatic billing, correct?
SIC uses, and it's NISC. I'm sorry, I don't know what the acronym stands for. It's a contract to do our billing. But as of May, we did not have bills sent directly out. It was sent to the office because if we had to stop it, we wanted to stop it.
So does NISC stop automatic billing for SIC?
It should have, but just to make sure, we had all bills sent straight to the office rather than directly to the customers.
So is it your testimony that by sending the bills to the office, that stopped automatic billing as of May 31st, 2024?
Yes.
And if that turns out not to be the case, do you have any issue with a commission order that any automatic billing after that date be refunded to customers?
None at all. We do not want any money for something that we did not provide.
Do you know whether SIC's customers or former customers, as of June 7th, 2024, have a competitive, reliable, alternative form of service at reasonable rates?
I do not know. Unless they were Spectrum customers. Spectrum could definitely provide it, but other than that, I do not know.
Can you elaborate on that response? What do you mean by Spectrum customers?
As I had said earlier, Spectrum had an agreement with Clearcom whereby they were using facilities, Clearcom facilities, which included some SIC facilities, to provide service, data service. Spectrum did not run it through through our lines. They put in their own lines.
And sorry, going back to a prior line of questioning, based off of SIC's intent to stop automatic billing effective May 31st, 2024, would you object to an order from the Commission that NISC cease all automatic billing through its system as of that date?
I would not object to it because I think we issued an order like that with NISC. So I certainly don't object to the Commission seconding that order.
Thank you. No further questions, Chair.
Thank you, Mr. Boone. Let's move to questions from our commission's attorneys.
Could I
Sure.
do a redirect to myself?
Do it now. Redirect. Yeah, it will be after.
From his questioning?
Yeah, questions. Right? Let's go through all the questions. If you can note it, we'll come back. We'll note that you do want to have redirect. How you doing, Jessica? You good? Okay, just let us know if. All right. So, Commission Counsel.
Thank you, Chair. Hi, Mr. He. I'm Caroline Yoshida. I'm Chief Counsel of the Commission.
Okay?
Let me know if I'm speaking too quickly or if you need me to
I'm
repeat
having
something.
difficult hearing you.
Okay.
Yeah.
I can. All right. Let me move the mic closer and I can talk louder. Is that better?
That's a lot better.
Okay, great. I just had a few questions to clarify some of your answers to Mr. Boone's questions, just to make sure I understood what you were saying correctly. So just the first one is pretty basic. What's the current number of customers that Sandwich Isles has, would you say,
Today,
today?
I do not know.
You don't know. Okay. But it's not zero.
It is not zero.
Okay. And do you know where the service outages currently are across Sandwich Isles service territories right now?
I can tell you generally, and if I could just digress a little so that you understand why I cannot tell you specifically. Sandwich Isles started out with a decentralized system. It eventually built a centralized system. So a decentralized system, we had 7 central offices throughout the state. They did not have to be interconnected with each other. They were standalones. It's a very expensive way to provide service. The plans that were approved was to initially do a decentralized system and then to centralize it, which would mean that instead of 7 switches, we only need 1 switch. And from that 1 switch, we could provide service out to the entire state, provided we had the transport. So as we shifted over to a centralized system, we had to lease transport. The bulk of it came from Spectrum. When we ran out of money, those were all canceled. Or not all, I think 1 or 2 still exist. Because those trunks emanate from our switches located in Mililani out to our customers through other switches. I cannot tell you for certain which customers are on which trunk. Okay. So I can generally tell you what areas have been stopped. I cannot tell you for certain. Okay.
So based on what you can tell me, what areas are those?
I believe Molokai, Maui, Kauai, west side of the Big Island, west side of Oahu. I believe those areas have all stopped. Now, once again, we did not turn off our switches. So if for whatever reason Spectrum did not terminate the trunk when they were given the order to terminate, there might still be remnant service.
Does anyone out in the world know where those areas are, if you don't know?
I do not know.
And it sounds like based on what you've said that given the termination of employees, there's no one from Sandwich Isles out there assisting customers with any outages at this point in time.
No, there aren't. And just to kind of reiterate or by way of explanation, with digital switching today, okay, if I wanted to terminate service, it's very easy. I turn off the switch. Okay? That wasn't what we tried to do. We terminated service because we ran out of money. We couldn't afford the employees. We couldn't afford the trunks. Okay? So we canceled those. We terminated. The telecommunications business is such that I don't doubt that there may be some trunks still alive. just because the company that we terminated the trunk with has not gotten around to terminating it yet. And our digital switches are still on. Digital switches don't require someone there to actually do something unless there's a problem. Okay. We don't have anybody to fix the problem. But the digital switch is such that it will continue to function until I turn it off. I have not turned it off. So that's why it's difficult. That's why we don't do any forward billing, because I don't know who the customers are. I'm not going to bill somebody that might not have service. So we essentially have no customers on a billing standpoint, but on an actual standpoint, we may.
Do you intend to turn off any of those switches in the near future?
No, but we do intend to, once the contractual obligations are done, to end the trunks that allow us to fulfill those.
Do you know when, what time frame that is in?
Sorry, I don't have that information.
Do you still have any remnant customer bill payments coming into you?
Well, that was one of the things that I wanted to clarify. In the Consumer Advocates opening, they spoke about billings and credit ratings and these types of things. Sandwich Isles doesn't do any of that. When we established the company, unlike the prevailing industry norm, we did not ask for any deposits to start service. Okay? We do not turn over the bills that are in arrears over to a collection agency. We absorb it. We do stop service after, I don't know what the final one was, like 4 or 5 months of not paying your bill. Then we will stop service after asking you to pay your bill. We don't go to collection agencies. We don't ask for deposits. We don't do any of those things that normally is done with utilities. And that's just an internal policy that Bob Kihune and I decided that we should do, that was the right thing to do.
And are those timelines and those decisions that you made captured in Sandwich Isles tariff on file with the PUC?
I don't know. I probably not. I mean, it's an internal decision that we made that said, look, if there's somebody out there that cannot afford to pay their bill, it's probably a good reason they cannot afford to pay their bill. We'd like to give them the benefit of the doubt that they cannot afford to pay their bill. And so after a period of time, we end service. But if they couldn't afford to pay the bill when they had the service, they sure as heck cannot afford to pay the bill when they don't have the service. And so we're not going to try to collect. It was internal. We just take it as a loss.
But you do have a tariff on file. Sandwich Isles does have a tariff on file with the PUC.
I believe
correct?
so, yes.
So just to clarify, your answer to whether Sandwich Isles still has remnant customer bill payments coming in, is it that you don't know?
It should have all been stopped, but like anything else, when you have something automatic, it depends on somebody else. And so I know that before the end of May, I had instructed the employees to stop all of those. If it's a glitch in somebody else's system. A lot of these automatic payments are through banks, right? And so the bank has to get around to do it. But, you know, our policy is always been, will remain the same. If we have money that we don't deserve to have, we will give it back as soon as we can figure out that we have money that we don't deserve to have.
Okay, so you're willing to refund payments
Absolutely.
to customers?
Absolutely,
if-
no question about it.
Okay, thank you. A few times over the course of this hearing, you've said a few things like the current crisis is the result of many years and much correspondence that you knew over time, that you were coming to a threshold here, and obviously that you've said that Sandwich Isles has run out of money. So my question is, why then did you not provide the PUC, the consumer advocate, and Sandwich Isles customers with at least 30 days notice before discontinuing service?
Well, a couple reasons, as I tried to explain in my direct. We believe that the PUC has limited authority, that its authority is granted through the FCC and the HHL. Okay. And we don't know what those authorities are. We certainly file all the reports that are requested of us and have been doing so. But we believed that the true regulatory agencies, as I went through when we set it up, was the FCC and the HHL. Okay. And so we have been in intense contact, or try to be in intense contact with them for many years about this coming crisis, or this point at which there's no more money, to try to do a rational transition. I was asked to solve a problem. I solved the problem. If they want somebody else to solve that problem now, I'm okay with it. But I don't see, and that's what I expected in the auction, that somebody else would step up and say, we will solve this problem. Okay? And so we didn't expect to end service. We had always been losing money. Okay? But we were willing to continue because we know what it means, and there was always an opportunity to recover that money. And so at the auction, Waimana put in a bid. If Waimana got that bid, was the big winner, it could continue because it could recover the costs. Okay? So we didn't know. But once the Department of Justice selected Hawaiian Tel, even though it didn't go to confirmation yet, okay? Once they selected Hawaiian Tel, it was too steep a hill. And so Sandwich Isles ended. And, you know, again, I say, the auction, what we were interested in is exactly why we got into business. We were interested in making sure that all Hawaiians on Hawaiian homelands have service. If they don't want me to do it, that's fine. But somebody's got to do it. And they selected a bid that Hawaiian Tel said, not us. We want all of your infrastructure that you built, Sandwich Isles, but not us. We're not going to serve those people. It was the same attitude they had 30 years ago. Except back then, they said, we don't have the infrastructure. But now we understand, because the infrastructure is there. So really, not having the infrastructure 30 years ago was just an excuse. Now you see the true, what it is. It doesn't matter what I do, what's there. They don't want to serve Hawaiians on Hawaiian homelands. Okay? I don't fault them for it. Their business model is commercial customers, residential customers if they're profitable. Spectrum's business model is residential customers because they started out with cable TV. commercial customers, because they definitely will be profitable. Sandwich Isles' motto was unprofitable customers. Pure and simple, unprofitable customers. And oh, by the way, if we can have some customers that actually are profitable, those profits go to pay for serving the unprofitable customers. Okay? That's what Sandwich Isles was created for. That's what Sandwich Isles did. So what we expected in the auction was, now we build this infrastructure. It still is probably unprofitable to serve it, but it's definitely doable. Okay? We expected a bidder to step up and say, with this infrastructure, we will take on this challenge. And Hawaiian Tel said, we want your infrastructure, we don't want the challenge. Okay. So now, and then you say to Sandwich Isles, you serve them. Wait. Now I don't have the infrastructure, and I'm going to serve them? Something's missing here, okay? And it got to a point where unless the regulators take control of this, unless this, public safety is not a private party's kuleana. Public safety is the kuleana of regulatory bodies, of this body, of the FCC, of Hawaiian Homelands. It's not Sandwich Isles kuleana. Okay? 30 years ago, the FCC, the PUC, and DHHL said, Sandwich Isles, solve this public safety on Hawaiian Homelands for us. And I did. And now they're saying, keep doing it, continue to do it, but you know what? We're going to take away all your infrastructure that you needed to solve this. But you keep doing it. I'm a loss. I mean, the irony in that is beyond me. And luckily, we have the Constitution that says you can't do that. If you're going to force me to serve, I have to be compensated. Otherwise, that public contract with the public utility is no longer valid.
Thanks for that answer. A few minutes ago, you mentioned the FCC. So my next question is, did Sandwich Isles comply with the FCC's rules for discontinuing service?
The FCC rules for discontinuing service is 30 days, right? We had told the FCC years ago that this was going to happen. Okay? We didn't have a date, but we have been in negotiations with the FCC over 10 years, saying this is going to happen. You have stopped universal service funds. You are now set in motion confiscatory rates. The only thing that happens when a utility cannot recover its costs is that it goes out of business. That's the only thing that happens. So, we believe we have given ample notice to the FCC that this was going to happen. The latest being, and it's in the subpoena, a letter from Mr. Smith to each of the commissioners at the FCC. That was the latest notice, and I think it was the 6th of May. So technically, I guess we met the 30-day, but the reality is we have been in negotiations with the FCC for 10 years. And there was always a hope that the FCC would restart this. because they have one open decision that they made on universal service funds, and we had asked for reconsideration, and they never acted on it. So if they had acted on it and said no, this would have happened many years ago. Okay, but it was there. So there was a hope that Sandwich Isles would become solvent again, and so we continued. But after this auction, I mean, you take away all the Sandwich Isles, you take away all the infrastructure I built to provide service to them, and then you say, oh, not only don't you have the infrastructure, we're gonna, as part of your certificate of authority, you have to keep serving these customers until we can steal them all, because you got to port the numbers, you got to do all of these things. So we have some of your revenue now, we're going to take all of your revenue, and then what? I still have to serve? So it just doesn't make sense.
Just a couple more questions. The Sandwich Isles has filed an annual financial report with the commission for, I would say, probably the last 20 plus years. Is that correct?
I will have to take your word on it. That's not something that I'm sure that we did it. I don't know when the last time it was done, but we, up until the end of May, we had people that were responsible for making sure that all of those things were done. So I would.
We have
I
a copy.
believe it's true.
We have a copy in our exhibit binder, which actually, would you mind
Okay.
bringing that to him?
That's fine.
We can just point that out to you. So
No, that's fine. That's fine. I believe these people that were working for us would do that. So I just don't want to say it out of turn if it didn't happen. But yes, I believe it's true.
and this will be my last question. Are you aware that the certificate of authority that you have with the Public Utilities Commission requires you to comply with all commission statutes, rules, and orders?
I am aware of that. I believe that we do that. As we started out in this hearing, that certificate of authority is actually issued to competitive exchange carriers. Sandwich Isles is not a competitive exchange carrier. That certificate of authority was a compromise that this commission, under Chairman Yuki Naito, decided to make. We had initially applied for a CPCN, and after, I believe, 3 or 4 years, they finally made a decision, and it was with a certificate of authority. But Sandwich Isles, as I explained, cannot compete because its financing doesn't allow it to compete. So it is not a competitive carrier.
No further questions from me, Chair. Thank you, Mr. He.
Thank you.
Thank you. I'll move now to Commissioner Yost for any questions that he may have.
Thank you. Thank you, Mr. He. Can you hear me okay?
Yes.
All right, I'll try to speak into the mic. Let's begin with a question relating to the auction on May 20th. Do you know what assets of Sandwich Isles were purchased by Hawaiian Tel on that date specifically?
I'm sorry. I gotta laugh because in 2020, the RUS obtained a money judgment against Sandwich Isles, and I believe a writ of execution was executed on the assets of Sandwich Isles at that time. those were those assets, with the exception of the Inter-Island Cable, were what was up for auction. Sandwich Isles has built other assets since 2020. Those are not up for auction. But, so generally, that's what it is. What was the assets that were up for auction. It is what I term as middle mile and last mile infrastructure.
Okay. Did Hawaiian Tel purchase all of the assets that were up for auction on May 20th?
No. Hawaiian Tel's bid, and it's public record, and I'm sorry I didn't think of bringing it, specifically excluded Sandwich Isles last mile and Sandwich Isles customers and all of its customer relations, which I believe are in industry jargon, the billing, et cetera, information.
And was it your testimony that Waimana bid on the assets that Hawaiian Tel did not seek to purchase?
Waimana bid on all the assets. The bidding procedures allowed for bidding on all of the assets or on part of the assets. Hawaiian Tel bid for part of the assets. Waimana bid for all of the assets. We agreed, and the bidding procedures were a result of mediation and then was confirmed by the court. And we were agreeable to allow bidding on part of the assets, provided provided there was continuity of service. Okay. We didn't understand why somebody would want to do that. What we were interested in was continuity of service as required by Sandwich Isles license with DHHL.
When you say we, are you now speaking as a representative of Waimana?
Oh, no, SIC.
Okay.
Waimana was a bidder,
Okay.
but SIC, I was involved in the mediation but we were represented, SIC was represented by counsel.
Okay. But Waimana's bid was not accepted at all? Is that what happened? Is that the ultimate?
It was not accepted as the winning bid. It is identified as a backup bid under the bidding procedures and under the motion for confirmation.
Our counsel, Caroline Ishida, in her discussion with you, you said you agreed that you understood the certificate of authority issued by the PUC requires SIC to comply with PUC rules, correct?
Yes.
And when that certificate of authority was issued, part of what the PUC had to do, and none of us were here at that time, but under HAR 6-80-18, the Commission was obligated to assess, prior to giving a certificate of authority, whether the applicant possesses sufficient technical, financial, and managerial resources and abilities to provide the proposed telecommunications services in the state, and that the applicant is fit, willing, and able to properly perform the proposed telecommunications service and to conform to the terms, conditions, and rules prescribed or adopted by the Commission, and also that the proposed telecommunications service is or will be in the public interest. Does all of that sound correct to you? Are you familiar with those requirements?
I am familiar with it, and I will tell you that the previous commission required me to put up $1 million in cash to satisfy the some of those conditions. The previous commission has never asked for any cash from any other certificate from any other applicant for a certificate of authority.
Okay, well, as you sit here today, as Sandwich Isles sits here today,
Yes.
do you represent to us that Sandwich Isles continues to be fit, willing, and able to properly perform telecommunication service to customers?
It's fit and willing, it is not able.
And does Sandwich Isles have the capacity to restart service? If we were to order that you restart provision of service, or if someone else, some other authority were to order that, do you have the financial and personnel and technical capacity to perform that restart of service?
As long as that order to restart service has money attached to it, yes. But again, it comes down to, can you order a utility to do something that it loses money at? So, you know, when I understood the need to, or the requirement, not need, but the requirement to follow all laws and regulations under the PUC, right, with the certificate authority. I understood that to be that was part and parcel of this contract as a public utility. That we provide service, we follow all of the laws and regulations and rules, etc. And the regulatory body ensures that we are able to recover our costs. Okay? So it is part and parcel of a contract that we have with the regulatory agency. What we have said here is the main authority with the regulatory agency is the FCC, because the FCC is the one that has the funds that can set non-confiscatory rates. You do not.
Do you have any, sorry to cut you off, but do you have any indication at all that the FCC has any intention of providing you with funds to restart service in Hawaii?
I have no indication.
Okay, thank you. Employees, you've said as of June 1st that you are effectively the only employee of SIC, correct?
Yes.
And does that mean that there is literally no one else who may still provide some kind of assistance to SIC customers? I mean, what about people at Waimana? Are any of them in the background sometimes providing help?
Waimana, Clearcom, Pamukkani, the other affiliate companies all have their own businesses, and we were able to absorb many of the employees into those businesses. They are available, obviously, and I want to make sure that everybody understands this. I don't own Waimana anymore. I don't control Waimana. I'm an employee of Waimana. Okay, and those decisions are made by the owners and directors, which happen to be my family. But, you know, I don't know when's the last time you got your wife to do something or put up money when she didn't want to. But, you know, they make those decisions, not me. Okay? So, yes, we do have employees that we can restart if we can get money. And, you know, I'm pretty sure that Waimana, Clearcom, and others would be more than happy to have those employees go back to being employees of Sandwich Isles and providing service.
But you don't have
they
any.
also-
Do you have any prospect of getting money? Like that, you said the money is essential to you being able to restart. The FCC is not giving you any money, as you said. Is there any other source of funds that would enable you to restart service to SIC customers?
There's two. One is from you. docket 2022-0218, which allows Hawaiian Tel to deny Sandwich Isles revenues from Sandwich Isles infrastructure. And Hawaiian Homelands has issued a right of entry to Hawaiian Tel to use land that was granted to Sandwich Isles, and Sandwich Isles gets no compensation for that. So there are two sources of revenues that are available if we can get regulatory. One is from you, which the decision was supposed to have been made 120 days after the filing of this complaint by Hawaiian Tel. And the reason for 120 days was because the sole criteria is economic harm to Sandwich Isles. The longer you leave this open, the more economic harm occurs to Sandwich Isles. And right now, it's been almost 4 years. We've been suffering economic harm because this docket was not decided.
Yeah, Mr. He, that's an open docket separate from this proceeding, but I thank you for your answer.
Well,
I'll
okay, but you're
take
asking
that
me
into
if there's
consideration.
revenues. That's one.
I
The other
understand.
revenue is from DHHL.
Okay. Okay.
Okay.
My last question is, you've gone into some detail, kind of an argument as to whether Sandwich Isles is competitive or a non-competitive service provider.
Yes.
But do you understand that the PUC rules include obligations of notification of customers and the consumer advocate and the PUC in either case, whether the telecommunications provider is competitive or non-competitive? The differences are, in large part, the length of time that the notice must be given. If you wanted to assert that you were non-competitive, you would have had a 6-month obligation, 6 months in advance, in order to comply with PUC rules. Do you understand that?
A couple of things, Commissioner Yost. The certificate of authority that was issued back to Sandwich Isles, as I tried to explain, was some sort of hybrid that the PUC at that time, came to grips with. We were looking for a CPCN because we were not a competitive carrier. The PUC at that time decided to do.
Sorry, Mr. He, you were granted a certificate of authority. It wasn't a hybrid. It's a COA, correct?
Yes.
So it's while it may or may not be the case, and it's hard for us to know sitting here today what discussions took place at that original proceeding, the outcome of that proceeding, which has been in effect for many years now, is that SIC was granted a COA, correct?
Yes.
Okay, and so I'm only talking about a COA. That's what you've got, and there are rules, as we've discussed and established through this back and forth, that govern what happens to a utility that operates under a COA, correct? You're not disputing that.
I am not disputing that.
Okay. I don't think I need to belabor that any further, and that's all the questions that I have. Thank you for your answers.
Thank you.
Thank you, Commissioner Yost. Commissioner Kuai.
Thank you, Mr. He. You testified earlier that after the FCC granted Hawaiian Tel basically all the assets, it was an uphill battle. Can you elaborate on what you mean by uphill battle for Sandwich Isles? That was in your.
I'm sorry, I didn't follow that. The FCC granted?
I'm sorry. Well, you indicated, or I should say, when Hawaiian Tel was granted Sandwich Isles assets, I think it was May 20th.
Oh, the auction.
The auction.
Yeah, that's DOJ.
Sorry,
FCC
Department.
is-
Sorry, DOJ.
Okay.
It was an uphill battle. Can you elaborate on that, please?
Yeah, it was yes. The confirmation actually was supposed to be done right away, and it wasn't. But we recognize that when DOJ puts its weight behind one bid, it's an uphill battle to overturn that. That's what I meant.
And did you realize at that time that there's no way that Sandwich Isles could operate and service its
Yes.
customers?
Yes.
At that time, why didn't you issue a notice to the PUC, the Consumer Advocate, and your customers?
It is my fault, absolutely. We believed that because the PUC's authority oversight wrongly, apparently, but it was our belief that the PUC's authority was ceded to it by the FCC and by DHHL. And so when we kept the FCC and DHHL apprised of this for years, we believed that that satisfied it. If we're wrong, we're wrong.
Thank you for acknowledging that. Can you, a couple of times you've mentioned Waimana and some other companies. Can you explain what Sandwich Isles' relationship is to Waimana?
Waimana is a parent company, much like HEI. And actually was set up, although the Public Utilities Holding Act deals with electric utilities, it was set up very similar structurally.
So they're essentially the parent company, like HEI is to HECO.
Yes,
Okay.
they are. The other companies are wholly owned subsidiaries. They were set up because of the regulatory issues and the regulatory requirements that existed at the time. When Sandwich Isles, when we did a partial assignment for voice only to Sandwich Isles, is because if it was for other than voice, RUS couldn't lend money.
So, I guess, given the fact that you knew as of May 20th that you weren't going to be able to operate and serve, did you ask your parent company for basically bridge financing to carry out your 30-day obligations?
We didn't know it on May 20th. DOJ did not disclose Hawaiian Tel's bid to us until, I believe, the 24th.
Okay, but
Okay.
did you ask for
The
funding?
parent company has been providing a line of credit to Sandwich Isles for years. It is, I don't know what the total was, but it is in the millions. Okay. The parent company said enough. The parent company, Waimana, said, look, if somebody is truly interested in providing service to Hawaiian homelands, then Waimana that's why Waimana put a bid in. That's why the parent company put a bid in. But if no one is truly interested in doing it other than Sandwich Isles and Waimana, then that's not our kuleana. We're not the regulatory, we're not the people that are responsible for those Hawaiians out there that don't have service. We were the solution.
But, Mr. He, you have a certificate of authority with this commission to be able to provide service to the customers that you indicated in your application to us. Is that correct? Okay, which included the DHHL customers. So until you decided, or until you determined that you had to abandon service because of a lack of funding, which is understandable, I get that. The only issue that I have is, why did you not provide the commission, the consumer advocate, and your customers the 30-day notice as required under law, so that adequate, I guess, service could be provided, including the porting of numbers?
We did provide that to our customers. We did not provide it to the CA and to you. But the CA has pointed out If you look at the documents that we submitted in our subpoena,
Wait. Let's back up. You provided an official notice to your customers as of what date?
there's no hard date. Because we didn't know a hard date. If they had accepted Waimana's bid, we would have not stopped service.
The documents that you provided, as well as the consumer advocate provided, said you were going to cut off service on June 8th, which you testified you did. But
Yes.
from May 20th to June 8th, obviously there is no 30 days from May 20th to June 8th.
Yeah, I understand that, Commissioner. What I'm saying is we kept the customers apprised of what was going
That
on.
does not constitute an official notice, Mr. He.
Then that's what happened.
Okay. And again, it goes back to, given the fact that Waimana is not providing, I guess, any financial support, is Waimana at least assisting Sandwich Owl's customers in the porting of numbers and other issues that Sandwich Owl's customers are experiencing?
Waimana would if it's legal.
Didn't you just testify earlier in response to Commissioner Yos's question that as far as some customer assistance, that some of the subsidiaries, including Waimana, are assisting Sandwich Owl's
The
customers?
employees. And let's make sure that we keep this, because the consumer advocate said something that is, I want to make sure that we're clear. Okay, these are separate corporations. There is no piercing of the corporate veil here. These are separate corporations with separate business models that pay separate taxes that were formed at different times, and they are true corporations, each with their own employee IDs and federal numbers. Okay? Waimana was the first of the corporations. I created it because I was doing power plants, building power plants. So these are separate corporations. I want to make sure that's very clear. Secondly, one of the reasons that they're separate corporations is that each of these corporations engage in businesses that are substantial, that are hundreds of millions, and therefore they have substantial liabilities. And so that's the other reason you have separate corporations, is to keep the liabilities within the corporation. So, in answer to your question here, Waimana has agreed to make its employees available to deal with unwinding, any issues of unwinding. Okay? When you
Can you explain what you mean by unwinding?
if the court,
'Cause unwinding from a corporate standpoint?
no.
Okay, because that's usually when we talk about unwinding.
Oh,
That's
yeah,
what
I'm
it is.
sorry.
Sorry.
Well, okay, I'm sorry. Transition.
Yes,
How's
sure.
that?
Okay.
Waimana has agreed to make its employees, and Clearcom has also agreed to make its employees available to Sandwich Isles in any transition period. It will be those employees that will make sure that we do not have any customer funds that that Sandwich Isles should not have. It will be those employees that make sure that
If the customers have any questions, are they assisting?
we have designated some employees, and they're all part-time now, okay, to monitor the info line, et cetera, et cetera. So we are trying to transition this, but
But they are Waimana employees that are trying to assist in.
And Clearcom employees, and there is still this whole looming issue of, was Hawaiian Tel's bid a qualified bid? And if it wasn't a qualified bid, then Waimana may end up with it. And then we're going to have to go from 0 to 100 as far as providing service.
So, okay, I guess as a follow-up to that particular answer, what is your intent? What is Sandwich Isles' intent? Is its intent to abandon its COA at this time, or what is your intent?
Regarding the COA, I have not considered an intent. I have not given that any thought. I will say that the FCC did a similar proceeding, initiated a similar proceeding on Sandwich Isles authority under the FCC. I think it's 214. I'm not
Okay.
sure. They initiated, asked for public comment, et cetera, then dropped it, or kept it open, I guess they say. Obviously, if SIC doesn't have a COA, if you folks feel that that's the correct thing to do, there's nothing that we can do about it. But then if Sandwich Isles, Sandwich Isles wouldn't do it, obviously. Then service to Sandwich Isles customers, if Waimana's bid is actually confirmed, will come through another company.
Okay. One last question. You mentioned that there's a bunch of contractual agreements with other companies, but you didn't have the details. Is it possible for you to provide us with copies of those agreements so that we
I can tell you who they are. I can't give you the details, but I can tell you pretty much.
Well,
who
can
they
you
are.
provide us copies so we can understand how long those, I guess, the service?
Yeah, I've got to have somebody go dig it up.
Okay, I would appreciate if you could provide that to us.
It's DHHL, it's the Coast Guard, and it's Target.
Okay, if you could provide copies of those agreements, we would appreciate it.
Sure.
I have no further questions, Chair.
Thank you, Commissioner Kuai. Mr. Lee, I just have a couple of clarification. You mentioned SIC was, I guess, in the process of paying back loans.
Paying
Paying
back,
back loans or loans that you obtained from the federal government.
oh, those have all been
You can-
judgments.
Okay, so they have been,
Not wiped out, but they're judgments.
okay. And I guess I want to make sure, in regards, to Commissioner Kuai, on the contractual agreements that's still outstanding. So one set is for, basically, I would characterize it as like internet type, right? Between between SIC, Clearcom, and by extension, Spectrum. Is that correct? Do I have that?
The agreement, yes.
That's one type
That
of
agreement,
contract.
yes.
Yeah. And then there's these other contractual agreements with like Target, DHHL, et cetera, right? That are
Coast
still
Guard.
Coast Guard that are still in effect, and that's why, in a nutshell, you haven't shut down those particular services, right? To those.
Right. We have to, I have to, and Commissioner Kawai is just reiterated, I have to get those and
Yeah.
evaluate them. But they were, at the time that we made these decisions, I knew they existed. And so I said, leave them alone until I can figure out what these contractual obligations are.
Okay. And from those contractual agreements that are still in effect, are you obtaining revenue from those contracts? Or is SIC receiving revenue?
Hopefully they'll pay the bill, but if they don't,
Okay, understandable, but I mean, it is a source, right?
hopefully, yes,
A potential source of other revenue to the company.
yes.
Okay, that's all the questions I have. I think I noted there was, you wanted to redirect, but I don't know if you actually completed that when, in response to our commission
No,
counsel's question.
I think after the questions by Ms. Shida and by the commission, that the issues that I wanted to cover in regards to especially the customers and any impact that they may suffer. I wanted to make sure that the information was out there that we don't do things like other utilities. We don't follow that norm, and so as far as impacting credit ratings, not returning funds, et cetera, no, that has a very high priority for us.
Okay. Okay, with that, the examination of SIC is complete. We'll turn to the CA. I know you mentioned that you would like to call Mr. He up as a witness, but how did you want to handle that?
So, Chair, based off of our earlier ability to question Mr. He, we do not have any further questions on direct at this time.
Okay,
Thank you.
so it sounds like both sides rest this time.
Exhausted.
The consumer advocate also rests, Your Honor. I mean, Chair.
Thank you.
Sorry.
Okay, so we'll move to, you know what, why don't we take a quick 10-minute break? Court reporter, she's been diligently recording, so 10 minutes, and then we'll come back for closing arguments. Those are, each party will have up to 15 minutes to make any closing arguments, starting with SIC and followed by the consumer advocate. But let's take a break. Come back here at 3:40. Thank you. back from recess. Believe we have a couple of procedural items that we need to take care of before we move to closing statements. We do need to move into the record, into evidence of the commission's exhibits. And Chief Counsel, did you want to identify?
Sure, they're the exhibits that are listed on the list that we filed on Friday afternoon and are in the exhibit binders. And Mr. He, you're welcome to this one if you want to take it. But they're largely publicly filed documents and things that are in the commission's records. But to the extent that there are some things in there that are not, we just wanted to move everything into the record to close the loop.
Any objections, Mr. He? No, yours are separate. These are just the commission's one. Okay. Consumer Advocate?
No objection, Chair. Thank you.
All right. So PUC's exhibits will be entered into evidence into this docket. Another item, I believe, Commissioner Kauai, you had, or our council had something.
Yeah, Mr. Key, in the middle of your SIC Exhibit 2, there's a bank account number that I suggest that you redact so that it won't get filed. Okay.
So Chair, I move to have staff redact Waimana's confidential banking information.
No objection.
All right. We will do that, Mr. He, to make sure. I'm sure we don't realize we don't realize those things a lot. So, Mr. Knox, you had, yes, that's the one. We're going to redact that bottom, all the routing numbers and check number and et cetera, just to make sure. Okay. With that, let's move to closing arguments. Mr. He, if you'd like to proceed, you have 15 minutes.
Thank you, Mr. Chair and Commissioners. I know it's been a long day. And I apologize for having to go back 30 years. I don't mean to, in my testimony, to disparage anything that has been done to date by previous commissioners. It's the facts, and that's all I wanted to do, was bring it out as the facts. Everyone does the best they can with the information that is given to them at the time that they have it, and the commissioners previous to you, as well as the commissioners at the FCC, as well as the administrators at RUS, made their decisions based on the facts that were given to them at the time, including the HHO. I'm sorry. But in the end, and as we did, as Sandwich House did, okay? Times change, facts change, circumstances change, and so decisions have to be changed. I understand it. But I think it's important in any decisions that are made that we remember why we are all, or what we are all trying to do. And what we are trying to do is ensure that Native Hawaiians can live on Hawaiian homelands wherever they are given a lot, wherever they are lucky enough to get a lot, and have adequate telecommunications. And that is a promise that Congress made to all Americans. This is not a Hawaiian issue. This is an issue of a promise that was made to all Americans. And we should remember that. If you want Hawaiians, Native Hawaiians, to be a full contributing member of society, they have to at least enjoy those promises that are made to all Americans. And telecommunications, given the importance of it in society, is a very, very important promise. Adequate telecommunications is an extremely important promise. You know, we don't hear this term anymore, but when they first started talking about telecommunications, they compared it to a highway. Right? It was a telecommunications highway. And it is as important as a highway to the rural areas. It is access. Access to healthcare. It is access to education. It is access to economic well-being. It is access to government. And so it is all of those things that if Hawaiians living on Hawaiian homelands are not given this access, they cannot be members of society. And they'll be left out, and they'll become more disgruntled. And, you know, it's just not a good thing. And that's what Congress recognized across the country when they put in place these promises. Farmers in Iowa, Arkansas, wherever, they needed to become a part of society. And rural electrification was part of it. Rural electrification telephone program was another part of it. The FCC's program of universal service funds was a big part of it. And when I was asked 30 years ago to try to solve this problem, it's not that I came up with some phenomenal plan. It's pretty simple. I viewed the problem not as a Hawaiian problem. I viewed it as a rural problem. That it was occurring on Hawaiian homelands was besides the point. This problem of not being able to get telephone service, carrier of last resort service, was a national problem. And Congress deals with these things with laws. So all I did was I looked at what Hawaiian Tel did for their subsidiary in Micronesia, and I said, that's interesting. Why isn't this being done for Hawaiian homelands? And I couldn't find an answer. Okay. And then I found out that there were several attempts, maybe not as wholeheartedly as they could have been, for rural companies outside of Hawaii to try to come in and do this. Tel Hawaii is a very good example. And what happened is they found out that they couldn't do it. And they couldn't do it not because the laws were there, but because the political will wasn't there. And through the political will, administrative decisions are made. And so what I found out was that's why it hadn't been used by Hawaiian Tel in Hawaii. And so I was looking at something very separate that I believed would be the answer. At the time, Hawaiian Telephone claimed they had the franchise to all of Hawaii. They never had the franchise to Hawaiian homelands, but they claimed that they did. Okay. And so I went through the legal process of establishing that under the Hawaiian Homes Commission Act, you cannot go on to Hawaiian homelands as a utility. You cannot get that easement. You cannot exercise eminent domain. Only the Hawaiian Homes Commission can give you the easements to bring your facilities on. Now, no one looks at this other than, hey, okay, if you don't want electricity on Hawaiian homelands, don't give us an easement. That's not the point. The point is that who controls that? is not this body. Who controls that is the Hawaiian Homes Commission. And so when the Hawaiian Homes Commission asked me to look at solving this, I looked at what is your asset? Your asset is land and control of it. And I said, if you give me those easements to use for telecommunications, and tie those easements to be used only for telecommunications, and telecommunications throughout Hawaiian homelands, not just telecommunications in Nanakuli, not just telecommunications in Waianae, not just telecommunications in Papakolea. But if you take this license, you are bound to telecommunications throughout Hawaiian homelands. You have the basis of building the infrastructure necessary to serve all of Hawaiian homelands. And the Hawaiian Homes Commission at that time embraced it. And when I went up to the FCC and RUS, they embraced it. Okay? And so I was able to solve the problem. I asked Hawaiian Homelands if they want to do it. They said, no, you do it. We want you to take the risk. Okay, fine. I take the risk. I solve the problem. Now that I've solved this problem, and I've built this statewide network, and the statewide network is the best in the state, no matter what people say. Hawaiian Tel wants it. I don't blame them. They opposed me in getting the money to build it. They didn't want me to build this. They opposed me at the FCC, and they constantly opposed me. They wouldn't go into Hawaiian homelands, but they wouldn't let anybody else go into Hawaiian homelands and serve. And that's what I don't understand. Okay? And so I did it. I served them. Now they want it. They have every right to buy it. But now you see what they really want. They don't want to serve Hawaiians on Hawaiian homelands. They want to buy this network, this infrastructure that I built to serve only Hawaiian homelands. They want to use it to serve everywhere else in the state. This is not unlike Hilo Airport. This is what the state did. They said, we want this block of Hawaiian homelands. We want to build an airport that serves the rest of the state. And yeah, some Hawaiians will use it, so it's okay. It meets the Hawaiian Homes Commission Act. It doesn't. It doesn't. Native Hawaiians are not an afterthought on Hawaiian homelands. They are the thought on Hawaiian homelands. If you relegate them to an afterthought on Hawaiian homelands, as they have been relegated to an afterthought in the rest of Hawaii, it's only a matter of time. Okay. So that's what Sandwich Isles is all about. And I've tried to, regulatory regulations make your head spin. And I've tried to piece this way through and do the best we could. And, when we were at full strength, I had many, many lawyers that could do this. We don't have them now. I apologize if I have violated rules and authorities. They were not done intentionally. But if I have, I have. But in the end, all of these rules and regulations, we got to remember what they're for. And they are there to ensure that a service, a necessary service, is provided to all people in Hawaii, including those people on Hawaiian homelands. And I believe that the regulations were written with those purposes and should be enforced with those purposes. Given what has been said today, there's no doubt that we did not conform with a 30-day notice on the certificate authority. I admit that. I did not believe that that was one of the regulations. Well, I believe that that regulation was fulfilled in our discussions with the FCC, our ongoing discussions with the FCC. If I'm wrong, I'm wrong. I admit it. Okay? But here again, if in fact Hawaiian Tel will not serve those people on Hawaiian homelands, we're the only guys that can. And so if, 30 years ago, they said, do this, you have no infrastructure, you have no regulatory authority, you have no money, but do this. And I figured out how to do it. Got through the regulatory scheme, got the money, figured out how to do it, and I did it. Today, the way it looks is they're saying, you don't have any money, you don't have any infrastructure, and you violated the regulatory authorities that allowed you to build this, but, oh, by the way, keep serving Hawaiian homelands. I don't understand how to do that. And very frankly, that is beyond my capability. So if we've done something wrong, we've done something wrong. But I think we need to remember these regulations are to ensure that service is provided. And if we interpret the regulation differently, where we use the regulation to deny service, then I believe that we are doing a great disservice to not only the people of Hawaii and the people on Hawaiian homelands, but we are doing a great disservice to how these regulations are being interpreted. Thank you.
Thank you, Mr. He. Mr. Boone?
Thank you. I have to admit, I agree with a lot of what Mr. He just said. I think if you deny service to Native Hawaiians, you are doing them a disservice. And I think what the record showed is SIC violated this commission's rules, and that's why customers are without service right now. And that's just the bottom line. SIC has admitted that they didn't comply with the 30-day notice requirement. In my opening remarks, I stated that was a 7-day window. I was estimating from June 10th, when I thought service had terminated, to the June 3rd letter that was filed with this commission. Based off of Mr. He's testimony, I believe he stated that service actually was disconnected on June 7th. So there's 4 days that this commission had to try and patch something together. There's a lot of finger pointing going on, but I didn't hear any sort of accountability or responsibility for that failure. And I think the commission's order, as a result of this hearing, should take that into account. I'm just going to go down to, a couple of statements I heard that just really feel the need to react to. I believe Mr. He stated that public safety is the kuleana of the PUC, and he might have mentioned the FCC as well. I agree with that. But the commission needs proper notice in order for it to perform its duties. How can it perform its duties if a service provider, or excuse me, a telecommunications service provider isn't holding up at its end of the bargain? Mr. He mentioned multiple times about how I'm not sure who he was referring to, took away all of SIC's infrastructure. But the evidence at hearing showed that that order approving the sale hasn't gone through yet. So what we're dealing with is this interim period of time where SIC has failed to provide notice, where customers are suffering. And I think all of that responsibility falls back on SIC. Whether they are fit, willing, or able, they're the ones who failed to comply with commission rules, who got us into this situation. And just because they may or may not be judgment-proof or lack money doesn't mean that that responsibility should shift to anybody else. I think it rests squarely with SIC. Mr. He mentioned that Native Hawaiians are not an afterthought, but he also said he did not research anything before he decided to terminate service. Didn't care to check who might be impacted by that decision. And as a result, I think it really put a lot of people at risk. So in addition to that date change, there's I had argued in opening arguments regarding this concept of, customers being concerned about their impacts to their credit score and things like that in collections. I'll take Mr. He at his word. He stated that SIC has never sent any debts to collections. So I want to modify that argument. But I think when the Commission's able to review the entire evidentiary record in this proceeding, to include all the evidence that was produced on Friday, June 14th, 2024, by DHHL, I believe the record is going to reveal 3 salient facts that build off of SIC's failure to provide adequate notice. Kind of mentioned it already, but most importantly, there are areas where SIC customers live that present an obvious safety risk as a result, of SIC's decision to terminate service without proper notice. Mr. He has admitted to that. The shutting down of the company was prolonged, and it lasted over a month. We went through those various letters to customers beginning in May 21st, 2024. And I'm concerned that that may have created, for lack of a better term, a carrier who cried wolf scenario, where there was these repeated notices to customers that, hey, effective this date, your service is going to be shut down. And all of a sudden you get to that date, service is still on. And so because of this kind of yo-yoing effect, I'm concerned that customers didn't have the ability to adequately plan for the termination of service on June 7th. And if in fact service was terminated on June 7th, that was a day earlier than the date on SIC's last communication. And lastly, I believe the evidence is going to show concern that it was likely that some customers who tried to terminate their service while these communications were going on and even beforehand were having difficulties shutting down their auto pay and terminating that service. And a potential reason for that might have been the attrition of SIC's employees that was mentioned at the hearing today. So I mentioned 3 things: the safety risk, how the shutting down of the service, and how it just kind of yo-yoed back and forth, kind of left customers in a bad spot, and quite frankly, an afterthought. And then the third issue is a concern over customers able to get off of auto pay. So I just want to address this briefly, those 3 points. Again, Mr. He, when asked on direct examination, admitted he didn't research anything before he terminated service. The Department of Hawaiian Homeland's document production includes PowerPoint status updates at PUC underscore DHHL underscore GENBBU underscore 000033. It identifies 4 areas where customers are completely out of service options. And again, I apologize, I may mispronounce this for the 3rd time. Kahiki Nui, Keokea, Pu'ukapu, and some areas of Molokai are identified in the evidentiary record as high-risk areas. The slides indicate that DHHL was having to provide hotspots, Starlinks, and coordinating with other service providers to get at least some temporary service into those areas. The carrier who cried wolf that I mentioned, the evidence shows multiple warnings and false starts that SIC issued to its customers that it was about to discontinue service. There was a May 21st communication, the May 30th, the June 5th, and then the June 8th letters. And those were just the letters that we were privy to from the productions that have come in. Since that time, in SIC's document production, they also included a May 10th, 2024 letter. And again, I believe these letters could have created an environment where customers could have easily been confused and desensitized to the looming shutdown of SIC. And it could have actually slowed to transition the ability of certain customers to get off of SIC service. I don't believe customers who fell into this boat should be left to... Oh, sorry. sorry, I don't believe customers who fell into this boat should be left to scramble for an alternative option. And I believe if they're still trying to identify a service provider, they should have the option of maintaining SIC service while this commission takes over how SIC's operations can be terminated in an orderly fashion, with dates certain and clear milestones ordered by this commission. The evidence also showed a slowly deteriorating company, or a company that went from 100 employees at its max to 25 to 30. It's not clear to me who's currently monitoring the main email address. The consumer advocate is concerned that customers who sought to terminate their service and their auto pay were deprived of this opportunity. Customers who are unable to terminate their service with SIC may have had to pay for 2 bills. They may have gone out on their own and secured another telecommunications service provider. And in this economy, especially, that's a hardship that should never have been borne by customers. Again, this wasn't brought up at hearing, but this point is supported by the Department of Hawaiian Homeland's document production, PUC_DHHL_GEN_BBU_0000023, in which DHHL states that lessees cannot discontinue their auto pay. And as this docket remains open, I would encourage anyone who's listening to this proceeding, if they fell into a situation where they were an SIC customer and they were unable to get off auto pay, that they should consider submitting a public comment to this commission for their awareness. Based off the evidence, I would just reiterate the relief that we think is appropriate under these circumstances. Again, we believe the Commission should not issue an order allowing SIC to abandon or discontinue its service unless a couple of factors are met. HAR 6-80-123 has the notice portion of it under Part A, and then what comes after that notice under Part B. And we feel that these remedies are appropriate under HAR 6-80-123B. And again, so we're asking that this commission doesn't allow SIC to abandon or discontinue its service unless or until it's shown that 1, SIC has waived and reimbursed any customer termination fees in the last 3 months. 2, SIC has fully reimbursed customers whose request to terminate service or remove auto bill pay features was unduly delayed in the last 3 months. 3, SIC has shown that a reliable competitive alternative exists at reasonable rates for all of its customers who are on SIC's books as of June 9th, 2024. We're also asking that the Commission clarify that SIC may not be allowed to terminate service unless or until it obtains a certificate from the Federal Communications Commission, as outlined in that June 6, 2024 letter that I referenced in my opening. SIC should be ordered to come into compliance with all regulations, both federal and state, relating to number porting, as well as all regulations and contracts related to conduit occupancy, to include requests to furnish make-ready work. For every instance where SIC has wrongly refused to port a customer's number, the Commission should direct SIC to refund that customer the difference between what it has paid SIC since initiating the porting request. And then the last 2 points, the Commission should direct SIC to timely respond to, fairly consider, and approve all future bona fide conduit occupancy requests within 24 hours or per any contractual obligations, whichever is sooner. And then lastly, the Commission should consider issuing appropriate penalties to SIC, including fines not to exceed $25,000 per day for each violation of any of the above directives pursuant to HRS Section 269-28. A couple just housekeeping points I wanted to mention. There was discussion on whether or not SIC provides competitive or non-competitive service. Under 269-16.85, titled Retail Interstate Services, fully competitive by statute, telecommunication services are considered de facto fully competitive. So again, to reiterate, we believe 6-80-123 is controlling in this matter. And that's all I have, subject to any questions from the commission, but thank you.
Thank you, Mr. Boone. With that, do want to thank all of you for participating in today's hearing. And the commission will come to a decision on this matter. We'll take a look at the entire record, as well as all of the discussions that were happened today. We will be issuing a decision in order on this and any next steps that we need to take, given that decision in order. All right, with that, we'll stand adjourned. Thank you, everyone.